Any mention?
May I please, Your Lordship? My Lord, I beg to make a mention of item number 31. Item 31, my Lord. My Lord, I'm praying for some accommodation in this matter as it could not be settled during mediation.
It could not be settled.
What matter is it?
This matter is regarding payment of outstanding dues, my Lord.
2 weeks.
2 weeks, my Lord.
Yes.
Wait, much obliged.
May I please, Lordship. Lordship, I beg to mention item 29, Lordship. Lordship, this is a Nehu matter, Lordship. I've already informed the council. So.
No objection, Your Lordship.
The same matter regarding that
Pro rata employees,
Pro-rata
Lordship.
casual laborers, Your Lordship.
Some
why it's been heard, I think one.
Lordship, some difficulties there, Lordship. Today, I'm praying if this matter can be taken up after 2 weeks, Lordship. Deeply obliged.
Obliged, Your Lordship. May I please, Your Lordship, I beg to mention item number 39, Lordship. After 2 weeks, Lordship.
Bridget movement. What's the matter about?
It's about the pending
Salary,
Lordship.
No urgency.
No, Lordship.
Yeah.
Highly obliged, Lordship.
Right.
May I please, Your Lordship? Lordship, I beg to mention item number 36. I prefer 1 week time, my Lord.
Corona Kanta Rabha.
Yes, Your Lordship. Regarding appointment of assistant headmaster in Maniganj secondary.
Why? Ms. Assam not there.
Lordship, the conducting counsel is from Guwahati. He has some personal difficulties.
Doesn't matter what anyway.
Right.
Yes.
Lordship, I beg to mention item number 37 on behalf of A.H. Karanlang. He's indisposed, Lordship.
Here for the petitioner.
Yes, Your Lordship.
Yes.
Much obliged.
May I please, Your Lordship? Your Lordship, I beg to mention item number 22. I pray for 1
This
week's
is a
time.
Meghalaya Rural Bank matter, Your Lordship.
Ricardo.
Yes, Ricardo.
Why not doing it? Where's Mr. Day?
We are not ready, Your Lordship.
Item number 22.
Yes, Your Lordship.
You have no objection?
His Lordship, since they are not here, because we have only to file our judgments, Your Lordship. More or less heard, Your
Why
Lordship.
you? It's part heard, that's why I don't adjourn it. Where's Mr. Day?
He's here only, Your Lordship.
Why is not doing it?
Some personal difficulties, Your Lordship.
So
Okay,
it may be as a last chance, Your Lordship, because I come prepared.
1 week last time, otherwise
Obliged, Your
1
Lordship.
week, 1 week. This next as a fixed matter. Part heard matter will not adjourn.
Please, Lordship, I beg to mention item 32.
Yes.
In item 32, Lordship, we are supposed to file an affidavit.
19?
32. This is a part heard matter, Lordship. During the course of hearing, we are required to file an affidavit to bring on record the recruitment rules. We require 2 weeks' time, Lordship.
Okay. Yes.
Obliged.
May I please, Your Lordship? Your Lordship, I beg to mention item number 30, Your Lordship. The conducting counsel, Ms. N.G. Shilla, is still unwell, Your Lordship.
Unwell, but she came last time.
Yes, Your Lordship. She's on leave. Much obliged, Your Lordship. Similar prayer, Your Lordship. Item number 40, Your Lordship.
Lordship, I'm there. We are there for the respondents. This is regarding work charged employee, Your Lordship.
For regularization. The prayer is for regularization.
You have no objection?
Sure, so next week.
Next week. Obliged.
Much obliged.
Item number 1.
My lord, this matter again pertains to that Peninsula's Shillong to Dauki highway, my lord, where the compensation.
How many cases are there now?
My lord, it's,
excuse me.
I think this is the fourth one, Your Lordship.
this is the fourth one, my lord. There's one more because they have come separately, my lord. That's why there's one more case that's coming maybe tomorrow, day after, my lord.
See, the court has a good mind to, since all disputed facts.
Yes, my lord.
With regard to the, the part acquired and the part which has been used.
They have
for
encroached,
construction.
Your Lordship.
Yes.
Not encroached, used for construction.
Yes.
So I think we'll have to give it some kind of a, a committee held by Deputy Commissioner or something
Yes.
like that, over and above the act.
Yes.
There was a
Yes.
joint inspection, Your
No joint
Lordship.
inspection,
Yes.
no proper
Yes.
inspection
Yeah.
with regard to the external acquisition and what was the construction.
Yes,
done.
my lord.
And
That-
after that, then
Yes,
you
that
can
would
pass orders.
suffice.
Otherwise,
That- yes.
from court, with disputed facts.
Difficult
you can't-
to
Yes.
assess whether there has been any.
Because
So any
our
more cases pending, you bring them.
my lord, there's only one more clients they have come, which are filed already, my lord. Let all the matters become, then we can do that, my lord. Common order, my lord. Yes,
You can see it by the Secretary Revenue or something.
my lord.
Yes, heard Mr. P. Ubin. Issue notice
5 and 6, Your Lordship.
MST. Now, who's for the?
I am for 1 to
2.
4, Your Lordship. 5 and 6 will notice will
Yes,
have to go.
MST NIB with so present. For how respondents 1 to 4. No further notice to respondents. Stop issue notice to issue to the
5 and 6,
5 and 6 within 3 days.
my lord.
Just after 2 weeks.
My lord. Obliged, worship.
2.
Yeah, Lordship, this is a better pertains to the release of the retirement dues, Lordship. Here what happened, Lordship, the petitioner was appointed in the year 1989, Lordship, as Chokidar, Lordship, and subsequently in the year 2005, Lordship, he was promoted to the post of lineman, Lordship.
The 0.89 regular appointee.
Subsequently, yes, Lordship, yes, Lordship. Then, Lordship, my Lord will see page 29, Lordship. This is from the authorities, Lordship, to the petitioner herein, return from service. This is to inform you that you are going to be retired from the corporation service on 31st March 2024. And after attaining the age of superannuation of 58, therefore you are requested to submit all the pension papers to the office of the undersigned for necessary action for this, and pension papers are enclosed herewith. Now, subsequent, Lordship, he has submitted all the documents, like Lordship. Now, after the submission of the documents, Lordship, my Lord will see page 30, Lordship. Page 30. Now, page 30, this is a letter dated 7 July 2023, says that my date of retirement was, Lordship, 31st 12 2021, Lordship. Now, Lordship, at present I am getting the pension. Now, the other parts of the retirement benefits like GPF, gratuity and leave encashment, Lordship. Only leave encashment, the partial amount has been released, and there.
You should know. Who's the paying for MECL?
My Lord, I have to take a step,
Where's the
Lordship.
standing counsel? MS Kolni. Where's MS R. Kolni?
We'll take step by step.
Returnable in 3 weeks. Steps are taken within 2 days.
Hello.
Yes, also.
Item number 3.
Who's for the petitioner?
Bottle also.
ये प्रधान.
Lordship, this matter is relevant to the penalty of 3 stages, deducting
The, excuse me, what are we saying? NR?
yes, Lordship.
Yes, what are we submitting just now? I couldn't catch you.
Yeah. Lordship, I am for the petitioner,
Yes.
and petitioner has been penalized due to the penalty that is dated 21st July 2023 by imposing 3 stages of deduction of salary. Because of this penalty, dated the impugn penalty 21st July 2023 issued by the Registrar General and Commissioner.
Where's the
of
penalty?
penalties here, my lord.
Page.
Can you refer to
20.
yes, 20, my lord.
Yes. What is the penalty?
Yeah, penalties, this one. The main para, kindly let me arrow to read out. The main para only, the last para 10 at page 22.
Yes.
Now, therefore, the disciplinary authority in acceptance of the advice of the UPSC has decided to impose the penalty of reduction to a lower stage in the time scale of pay by 3 stages. By 3 stages means deducting 3 annual increments for a period of 5 years.
Yeah.
That is, for a period of 5 years means commencing from 1st August
What were the
2020.
charges against you?
Charges him, he just took some advance money for conducting some data dissimulation workshop, and another is relevant to the language.
In financial misconduct.
Yeah, financial misconduct. Whereas the petitioner has already paid the amount. So please refer to page number. This one. Yeah, at page number 44.
What do you mean by paid the amount?
Uh,
These are charges which are proven against him.
Yeah, that is 30,000 rupees.
Okay.
So at page number, kindly refer to page number 44.
Yes.
Where this is the statement. Submission of expenditure statement for organizing one-day data dissemination of workshop on 29th January 2015. I have the honor to submit here with expenditure statement for organizing one-day data dissemination workshop on 29 January 2015 at Conference Hall, Manipur Guest House, when I was posted once at Imphal in the Directorate of that Census Operations. By the time I took this, an amount of 30,000 rupees
Okay,
only.
Yes, what do you want now? Will issue notice? Yes.
My
No,
lord,
there are 2 issues, my lord. It appears that the period pertains to when he was in Manipur, my lord.
Yes.
Disciplinary order has been passed from Delhi, my lord. So territorial is one aspect, my lord. And second aspect, it appears that he will be subject to jurisdiction of CAT, my lord.
Yes. The court is going to point that out because you're a central government employee, correct?
yeah, he is presently posted here.
Operations.
Lordship, he is right now posted at the
But
Shillong.
where is he? No, he's under the government of India. His Home Ministry, correct?
Yeah, Mr.
Then
Home.
how you come before the High Court?
My lord, he is working here.
No, it doesn't matter. You have to go to the Central Administrative Tribunal.
Yeah, that is right. But it is a time-consuming thing, my lord. That's why I have
Time consuming
come
doesn't
over.
mean that the alternate remedy is there that you don't pursue the remedy.
Yes, I have to seriously agree due to this penalty. That's why I have come
You
over
agree
here.
with the penalty. This
To
CAT
submit
is there to
my
take up
prayer.
specific matters, to take instructions from your client. Otherwise,
I'll also have
Your
instruction.
your name?
My name is wrongly entered there as James. I am Dr. S. James, my lord.
Dr.
My correct name is Dr. James, James.
Heard Dr. S. James. The counsel petitioner, you should notice Dr. Mojika Venedia GI with so and so present except on behalf of all the respondents. Stop at the outset, Dr. Mojika has raised a question of is a question of availability of alternate remedy in as much as the petitioner's central government employee. Stop Dr. S. James to obtain instruction before the next date. Just after 2 weeks, you take instructions.
Item number 4.
Please, Your Lordship. Your Lordship, here the petitioner is working as a work charge pump operator, my lord, and thereafter his service was regularized, my lord, which is at annexure 2, page 14, my lord. Serial number 1, my lord. His service was regularized because he was appointed as a work charge pump operator.
He's retired, still working.
He's retired since 2024. on January, my lord. Prior to his regularization, my lord, he was also appointed.
Double benefits till now.
No, my lord.
Yes, you take instructions.
We'll take instructions.
Yes, heard MSS now said learned counsel petitioner issue notice.
My lord, notice has been issued on the last day.
Where's for instructions?
Yes, my lord.
Where's MSR calling you at the notice?
She is before the division bench, Your Lordship.
Like musical chairs, come and get. Yes.
So, Lordship, may you give me some time?
No, yes. What instructions? Any instructions?
We haven't
you have today?
received any instructions, Your
On
Lordship.
24th of February.
I am
benefits.
aware of that, Your Lordship.
Why no
I
instructions?
was also not present that day, Your Lordship, but I may be given a week's time, Your Lordship. We'll seek
I mean,
instructions.
today is
A date fixed for instructions.
It's fixed on instructions, yes.
Yes, Your Lordship.
Wasn't orders.
But it's
Yes,
fixed on
only listed for motion. Yes.
motion. It is. We haven't received any instructions, Your
Who's the
Lordship.
person responsible to give instructions?
Must be the Chief Engineer, Your Lordship.
Of PHE.
Or PHE, Your Lordship.
Today, MS T Yangi B, AG submits that instructions are still to be received. Stop. Stop. This court notes that's a case of non-receipt of term benefits of the petitioners retired since 2024. Stop. It's expected next year that the state respondents come forth with specific instructions.
Obliged, Your Lordship.
Yes, after 1 week.
5.
Please, Your Lordship, this matter pertains to freezing of bank account, Your Lordship. Your Lordship, my account was frozen on 25th of January 2026.
Yes, you served them. You corrected the defect.
Yes.
What was the
Annexure, we have received the annexure, Your Lordship. No, on the last date, it was when the
Which
motion.
bank is this?
Bank of India, Your Lordship. Lordship, I have no objection towards the amount which has been frozen, but however, my entire account has been frozen. So now I'm unable to function my day-to-day expenditure.
This is not the first case. This is
Disputed amount is 15,000, Your Lordship.
you just tried to effect notice by personal services on the Bank of India. Next date will pass necessary orders.
Thank you, Lordship.
Yes, this one,
And the state of Kerala is involved, Your Lordship.
no, at least for number 3.
But yes.
Yes, Mr. S. M. Rajao. Third so the counter petitioner. Notice MST Yangi B. Lele AG is present behalf of respondents number
1, Your Lordship.
1. No further notice to the said respondent. Notice issued to respondent 2 and 3. Stop as the matter involves the freezing of account of the petitioner. He is allowed. It is personal service on number 3 is allowed. List after 1 week for further orders. Yes. Along with proof of service. Yeah. On number 3.
Item number 6.
Please, Lordship. Lordship, I'm praying for some accommodation, Lordship. Mr. Shala is having some personal difficulties.
Already filed. You joined.
Yes, Lordship, I filed. Lordship.
You ready with the matter?
Lordship, I'm for the state in this matter.
Yes, you have filed objection. Who filed objection on maintainability?
The corporation.
MECL, yeah.
You ready? You ready with the matter today?
No, my lords, the conducting counsel, Mr. Karwalnang, is in his person.
When?
2 weeks, Lordship.
After 1 week is on the prayer of the learned counsel petitioner due to unavailability of the arguing counsel. That's what for 1 week.
Right, Lordship.
7.
Yes.
May it please, Your Lordship. Your Lordship, I'm seeking accommodation, Your Lordship. Mrs. N.G. Shilla is still not well, Your Lordship.
What's the matter about?
My lord will recall that departmental proceeding, my lord. Inordinate delay, my lord, more than 6 years, my lord, and I'm under
Absent
suspension.
Also, Your Lordship, from unauthorized absence also, Your Lordship. From
You know the matter, it appears.
Your Lordship.
My lord, I'd been, my lord.
It's for what? For admission hearing?
Admission hearing, Your
Exactly,
Lordship.
my lord, since a long time, my lord. So, my prayer will be, my lord, infructuous if it is not, at least miscase may be disposed, a stay may be granted, my lord.
Miscase for stay of the proceedings?
My lord, till the
That will
outcome of
amount
the, my
to-
lord, outcome of the, my lord.
Your Lordship, that will amount to granting final relief.
I don't think so, my lord.
So what are we to do?
I have been under suspension for more than 6 years, my lord.
I get subsistence allowance.
No, my lord. I'm
Your
not
Lordship,
getting.
there's an order. An order
There
has
is
been
an order,
passed
my lord.
granting
Then
subsistence
I was, my
allowance,
lord.
but no, Your Lordship, by the department. But the petitioner has not joined the place of posting, Your Lordship, because she was transferred.
No, my lord. That is one of the ground, my lord.
What
I
are the grounds for it? One thing in you.
My lord, firstly, my lord, there is
Unauthorized absence, Your Lordship, and she refused
where
to
were you
join
working?
her.
here in the DC office, my lord.
She was transferred, Your Lordship, to Sora, and she refused to join the place of
My
posting.
lord,
in
that is not the case, my lord. What has happened? That is a case of punitive transfer, my lord. That is one of the ground of challenge, my lord. I have taken up, my lord. What has happened, my lord? The entire proceeding took place, my lord, in a very, my lord, lightning speed, my lord, within a period of 25 days, my lord. That I am given so cause notice, and that too for a period that I was on sanctioned leave, my lord. And thereafter, everything happened rapidly in a lightning speed.
Why? What's wrong with happening lightning speed?
My lord, in 25 days, my lord.
Everyone says that not disposed of, taking time. Now we do lightning speed also. You're aggrieved. If you don't do it, also you're aggrieved.
So, my lord, the conduct, my lord. I'm trying to.
Or the conduct.
Exactly, my lord. The conduct of the official.
Tomorrow.
Your Lordship, after the week.
How do you argue in the matter? Yes. As mention has been made on behalf of the Legal Council of the State, this matter on Thursday. Hearing.
Deeply obliged.
Obliged, Your Lordship. 19th, Your Lordship.
Deeply obliged.
8.
Is your Lordship. But 5, 6 and 7 we file affidavit today, madam. Respondents 5, 6 and 7.
Yes.
We've received for Millards 5, 6, 7 and 15, 16.
Yes. Very bad connectivity.
I appear for the writ petitioners.
Yes.
Millard, your lordships want to Millard at the main matter heard. Directions were given Millard to complete the affidavits. I'm told Millard today, Millard, the respondents have served Millard copies of that affidavit. So lordships, Millard, kindly give us Millard an opportunity to deal with it, and subject to your approval, Millard, I would pray for Millard that set Millard, if your lordships kindly take it up.
Today?
No, Millards, we want to respond to these affidavits. We've just got it today morning.
I couldn't get with it. So all are filed. All
no, Millards, respond number 8 to 13.
I'm filing today. Very good. Then what about you? You're for whom? So that means, okay.
I'm for 5 to 7.
Yes, Dr. N. Musica, Leonard, Senior Counsel for 5, 6, 7, Mr. Iki Sutanga. No, you already filed. And you are Mr. Louder. And Mr. F.L. Dakhar for phone 16 submit after since been filed. Stop Ms. Iki Sutanga, Leonard Counsel for 813. Submit that after be filed in the course of the day. List after tweak for rejoinder of any.
Well, it's and the hearing, rejoinder and hearing with this also.
File rejoinder, yes.
Except first and second.
First and second of it.
Week starting from 7, 8, 9.
Millards, would it be convenient, Millards, if we have it around the
8th or 9th of April?
2nd of April, Millard.
2nd of April.
So second not a good day. Second not a good day because we're having a sort of
just before Millards, Good Friday.
Be there.
Week after that.
We'll fix the date. Yes, thank you.
9.
Yes.
Nine.
Yes, Mr. One Sweat.
Your Lordship, the respondent is supposed to file affidavits.
File. Dr. Mozika. File.
But we have not filed, Millard. We have 2 weeks time, Millard.
This is a Section 11 application?
Yes, Your Lordship.
It's a give a new updater only. What is it for?
But this is basically for, because they are suggesting the engineers, Millard. We are saying that the engineers panel is expired now.
No, no, I'm not supposed to file affidavit. You want to give what instructions?
It's just for affidavit, Millard.
No, your prayer that obtain instructions on the name that have been supplied by the next date. What names you supplied, Mr. Wanswell?
Your Lordship, the name from the Council of Arbitrators.
No, what? Yes.
They're suggesting some names.
No, what instructions have those names? Yeah, okay with the names they've given?
No, my lord.
Then?
We're not okay with that.
Dr. N. Mozika submits that the respondents are not agreeable to the names have been supplied by the petitioner. So we pray response allowed 1 week's time
1 week's.
to file an affidavit with names. File affidavit.
Not names, my lord.
Yes.
Oblige.
10.
Please, Your Lordship. Lordship, we have already received the affidavit from respondent. So we need. Lordship, we had filed the affidavit today.
1, 6, and 8, 9, file.
So we need 2 weeks time, Your Lordship, for
Your name?
agenda. S. Laman.
S. Lama.
Laman, M-A-T.
Laman. So S. Laman comes up with the petitioner. We have some 2 weeks time to file the joint affidavits filed by respondents 1, 6, and 8, and by 1 number 9.
Oblige.
This also. Oh, yeah.
11.
Where's MS
11.
Bisun?
Your Lordship, this matter was sent for mediation. Your
And what
Lordship.
happened?
It was not settled, Your Lordship.
It's already taken up in mediation.
Yes, Your Lordship.
MSZ Inokanti Learned Council Learned GA 4125 submits that the mediation proceedings were not. I'm sorry, the matter could not be settled in mediation. None appears for the petition list after. For hearing, it's an order stage.
It's in the order stage, Your Lordship.
Affidavits have been exchanged.
We have filed our affidavits, Your Lordship.
Yes,
The
after 2 weeks
petitioner is
of
supposed to
order.
file rejoinder. Obliged.
12. 12.
My lord, this matter is referred for mediation. However, none appeared on behalf of the respondents.
Why didn't appear?
My lord, I'm for the state. I'm for 1
Yes.
and 2.
Or the state is other party.
No, there are other
There are
private
other
respondents
private
as well.
respondents.
So pension matter.
Seniority matter.
Or same order. Matter could settle for mediation is after 2 weeks of further orders. All affidavits.
Not yet.
exchanged.
My lord, 2 weeks.
13.
High level.
Wait, please, Your Lordship. I'm praying for some time to file our affidavit.
Yes?
I'm praying for some time to file our affidavit, Lordship.
Yes? No objection. Yes, as prayed for the 2 weeks time allowed. The affidavit is thereafter.
Highly obliged.
14.
Well, for respondents 4 to 54, I'm filing my affidavits today.
We have filed, the state has filed the affidavit.
What's the matter about? Why so many respondents?
This is the appointment, my lord, of veterinary doctors. They've challenged the advertisement and the appointment.
MS, you already filed.
We have filed, Your Lordship.
Week's time, Your Lordship.
State respondent has filed.
MPSC.
I'm filing it today, my lord.
Yes, Mr.
4 to 54.
ACH Gautam, the counsel for respondents number 4 to 54, submits their affidavits we filed the course of the day. Mr. S. Naitang, however, for 3 days for further week's time. Week's time to file affidavits. Just after 1 week.
1 and 2 has filed, Your Lordship.
You want to file the joinder?
Lordship, I'll seek instructions, Your Lordship.
Yes, your name
And Sangma, Your Lordship.
and Sangma. Ms. N. Sangma, the petitioner, please wait out of the instructions whether the joinder be necessary. Just accordingly.
Obliged, Lordship.
Obliged, Your Lordship.
Please, Your Lordship, I have just received the affidavit this morning, Your Lordship, so I pray for some more time, Your Lordship, file a agenda.
You didn't go for mediation, didn't work out.
It seems it didn't work out, Your Lordship, because the department says that they have waiting for the response from the respondent, Your Lordship. That's
Your
it.
Lordship, it is under the examination by the department.
Now, what affidavit did you file?
We have filed the affidavit, Lordship.
Yes, you want to file a joinder?
Yes, Your Lordship.
Mr. D. Nyota, please send out to file a joinder to affidavit filed by the state respondents. Yes, up to 2 weeks, yes.
Right.
Please allow, yes, up to 2 weeks.
16.
60, sir. Mediation.
The mediation nahi the standard order is from that.
Yeah.
It's going for look at came up look at
My lord, here they have already admitted. They have admitted my dues.
So then you want to close it?
My lord, if the direction may be issued.
Let them let these both these cases be placed before their mediation, you know.
What for?
Come from look at that. After look at that, you get them to mediation, then back to look at that.
Lordship, the fact remains we have not disputed their bill, your lord.
Then we close it. What's how much?
22 in one. There are two cases, my lord. In one case, it is 22,62,127.
Where's the affidavit?
Affidavit is on the record, my lord.
Where they've admitted?
In their affidavit, my lord.
I have it. Yes, where is that?
Lordship, kindly have para 7.
Yes.
At page 3, your lordship. We have sought for administrative proposal, your lordship, to clear that dues.
So when those dues were payable? When?
It was long back, my lord. It was. In the year 2013, my lord. 13-14, my lord.
You're not claiming interest also?
I have paid for interest.
If a lordship kindly have paragraph E at page 4, your lordship.
Yes.
Lordship, that is the second paragraph, your lordship.
Yes.
Lordship, we say that it is pertinent to state that the planning department had to submit a proposal for leveraging of accumulated balance under so and so to the concerned authority by letter dated. However, approval and sanction of the same is still being awaited. In the subsequent years, several communications were made to the state government for sanction of the required fund.
No, but completion certificate only given to you.
Yes, madam.
Then what?
They have admitted.
What re-verification necessary?
Lordship, we say that fiscal verification of the work is necessary. Then thereafter will.
No. If you already get completion certificate, then what's the question of physical verification?
No, Lordship. Lordship, this it was placed on 21st March 2025, your Lordship, before the departmental committee meeting, your Lordship.
It is just an excuse, my lord. They have admitted. They have admitted in.
Where's the completion certificate?
Completion certificate, my lord. It's the bill. That's the reason why they have made a part payment, my lord.
Lordship, that
Lord, this page 15. This is the bill, my lord. And against this bill, they have made a part payment.
You find out, Mr. Shulai, when you can pay.
This is only the statement of our payment, your Lordship.
When you already admitted the affidavit, how long it take to pay the bill?
Lordship, because
Mr. N.M. Suri, letter counsel on behalf of the petitioner submitted that nothing remains for consideration, in as much as the respondents themselves in the affidavit filed has admitted the dues of the petitioner. Ms. Andy Shulai, though not disputing this fact, has submitted that.
Lordship, what
Certain
do
verification works left
Lordship, yes.
have been requested.
Then thereafter,
This court of review that since amount admitted, alert senior Senate AAG to take instructions as to when women can be made to the petitioner. Just up to 2 weeks.
Lordship.
Yes.
All right.
18.
Apply, your Lordship.
Lordship, 2 weeks time may be granted to obtain instruction from the petitioner.
What is this?
This is
Why instruction from you?
Lordship, some communication has been
On that occasion, I've given some documents, sir.
and that we have forwarded to the petitioner. We are yet to. This is she was.
What
in
documents
army.
did you give him? Rather?
But the documents indicate, my lord, that her pay fixation is
Has been
in terms
done.
of the rules, my lord.
Mr. S.T. Upadhyay, to the communication that was. No, it was your, please allow 1 week for the time of the instructions.
Lordship.
Yes, petitioner. Please allow this after 1 week.
19.
File.
My lord, I'm entering appearance on behalf of respondent number 4, opposite party number 4, my lord, in this case.
The 3 we have taken a steps, my lord, service is complete. We will file an affidavit.
Who's appearing for 3? Now, what has happened? But 3 has taken any action against you, or not? Now everything is.
But there is an interim order, that's why, my lord.
Well, the lease which was executed, I mean, that has already expired, my lord. The lease which was
But even who is the respondent number 3 to go and take law into his own hand?
my lord. The only thing is that the lease which on which they are relying, my lord, that has already expired, my lord, last year, since last year, September.
Doesn't matter. You serve.
We served, my lord. We will file an affidavit, my lord,
You are
because
appearing for
MS
P.S. Nongri, as on behalf number 2, and Mr. L. Kriyam for number 4.
4 months.
Do it submitted that steps have been taken on spot number 3. No appearance as yet on behalf of the said respondent. Stop. You already served.
we served, my lord. We will file an affidavit.
Dr. Mozika, however, submits that number 3 has already been served. Please be allowed to bring a service affidavit on board.
Well.
Yes, you want to file affidavit?
We'll file, my lord.
Just after 2 weeks for status report and for affidavits by. What about this council? Affidavits by respondent number 2 and 3.
The interim order.
Interim order shall continue the next day.
20.
This pertains to non-renewal of my passport. Some cases are pending against me, my lord. In fact, only one case has been charge sheeted. Now, the Ministry of External Affairs has a memorandum regarding cases, FIR or any case charge sheeted against a person, and whether the passport can be refused or not. Now, my lord, in the memorandum itself, it is very clear. Mere filing of an FIR will not lead to non-renewal or non-issuance of passport. Now, that being the case, my lord, my passport has not been renewed for, my lord, flimsy reasons. In fact, one case has been charge sheeted, my lord. I filed an application for grant of NOC. The court has, in its order, very clearly stated that there is no question of granting NOC because, first of all, I was never arrested. There are no bail bonds, and there is no question of any restrictions. But in spite of that, my lord, my passport has not been renewed.
Dr. Mozika here.
My lord, he has to go and approach the office, my lord. There is a communication, my lord.
I can't see you. Yes.
Your Lordship, we've already forwarded to your Lordship the police verification, your Lordship, on
Then?
26th February, your Lordship.
Then
But the instructions are there, my lord.
only non-forwarding of police verification.
That has been done, my lord. Now we have received, my lord. And we have informed. Next page, your lordship, kindly see.
Yes.
On 2nd March 26th
Oh, yes.
to so and so. police submitted adverse report. If you live in the vicinity of Passport Office Guwahati or have been specially asked to appear in person, you could choose to submit the required documents to the inquiry officer at the Passport Office or any working day by taking prior online appointment. So he has to go and
No, this does not specifically ask me to come there. My lord, it is basically, they say that the police have submitted an adverse report. No, but how can they submit an adverse report, my lord? I can place some judgments. But mere filing of an FIR against me, my lord, there is no serious case filed against me. I have not been convicted.
It's not a refusal as of now, my lord.
You go and meet them.
This part is auto-generated, my lord, what I believe. If you read this, my lord, what has been handed over to me. If I may read, my lord, police, number one, police submitted adverse report. If you live in the vicinity of Passport Office Guwahati or you have been specifically asked to appear.
Not here.
I have not been specifically asked to appear.
No, it is.
On second page, my lord.
Second page, my lord. This is something, it's a auto-generated thing in every other one. I have not been specifically asked to appear. They've only said that police have submitted an adverse report. Now, my case is that police cannot submit an adverse report in my case because, my lord, I have neither been convicted nor is any other case pending in any other
Tell
court.
them that.
Conviction is not required, my lord. He can go and meet the officers. That's my instruction.
You
My
meet
lord,
the officers.
then in the meantime, my lord, this petition will be kept pending, my lord. I'll make an endeavor because, my lord, if I just go there and if nothing happens, then again I'll have to come back here again.
Yeah, Dr.
Because otherwise,
is brief of communication indicating the fact that there is a adverse police report as regards the petitioner, which and a petitioner who has been requested also to appear personally before the Passport Office.
Yes, sir.
Yes, like Mr. K.C.H. Gautam, because the previous praise that he went out sometime to do the necessary.
Passport Office Shillong.
To and appear before the Passport Office at Shillong. Well, this is a matter after 2 weeks to await any outcome.
My lord, Shillong or Guwahati, maybe, because I'm not really sure about that.
It will be Shillong because I've made application here only. Consent passport.
Consent passport, not Shillong.
21.
Obliged.
Court of inquiry, okay. 21, 20.
I know I have.
For respondent number 7, Lordship, received and invited for is yet to file the affidavit, Lordship, because we will have to communicate with the respondent. Can you allow us 2 weeks' time, Lordship?
What? Communicate with whom?
He's supposed to come and meet us, Lordship.
Yes.
It's under curfew, Lordship. These are VC matter.
These are BC matter.
Yes, sir.
Come after 3 weeks.
As per it, further 2 weeks' time is allowed. Or Ms. R. Khakan submits that he. Not submit, praise him allowed further 2 weeks' time to file affidavit.
It will be 3 weeks, Your Lordship.
Because of the situation, Lordship. 3
Situation in
weeks.
Karo Hills. Lordship. Highly apply, Your Lordship. 23, 24, Your Lordship. These are connected. Apply, Your Lordship.
Together.
Hearing 25.
The petitioner is supposed to file an affidavit indicating what is the non-compliance. Well, we've not been able to do that also.
Lordship, I'm praying for some time, Lordship. We have instructed our clients, Lordship.
You're instructing your clients?
Lordship.
To file affidavit?
No, Lordship, they'll be coming here for signing the papers, Lordship.
What's the matter about?
This is a contempt. Since 2017. But there are two matters clubbed together. One, Lordship disposed of, Madhavendra Singh.
Initially,
that
two
was
matters
pertaining
to
to oral
Lordship.
and this is pertaining
One,
to
your Lordship
cycle.
has already decided. This is the other matter, Lordship.
But this has to same fate.
Lordship, may kindly allow us 1 week's time, Lordship, because it is almost ready, Lordship. They will be here, Lordship. The clients are all here. They will be here, Lordship. So we'll.
They are outside now.
Lordship, we have instructed them.
Here today.
Lordship, they'll be coming, Lordship. I'm instructed for signing the affidavit, Lordship. So Lordship may have it on next week, Lordship. In the meantime, we'll file our affidavit.
As Chanda submits that the affidavit on the additional affidavit on behalf of the petitioner will be filed in the course of the day.
Lordship, tomorrow.
This week, yes. This after 2 weeks.
26.
It's not connected.
No, it's not connected, my lords.
These three matters are
It is
connected. 26, 27,
26, 27, 28 are connected, my lords.
These are doctors' matter.
Well, this is that matter where your lordships recollect the earlier round of litigation was closed on a statement by the undertaking by the. We can fix a date for hearing, my lords, sometime next week.
Fix today for hearing.
My lords, insofar as my submissions are concerned, my lords, it's restricted to that only, and they have not filed any.
You filed affidavits, everything. Come up with 3 weeks. You know, adjourn, so I didn't prepare this matter as well.
Because where he all said will adjourn it. It's after 2
That
weeks.
was after 3 weeks. But there's a holidays, 1 week.
3 weeks.
Obliged. Let's item 33. This matter's come back from mediation. Mediation could not work out.
Good, other side.
Mr. Ravi Gurung is.
Has no settlement give arrived mediation proceedings. This is a matter for hearing after 1 week.
2 weeks.
2 weeks.
Your Lordship, he's on legs. It's the state respondent here. Sagurung is currently on legs.
Okay. Your name? You are called on behalf of. Oh, you're not government advocate.
34.
Section 11, my lord. Justice Vaipai was consent was required to be taken.
Yes. We'll pass orders then. We will receive the consent.
My lordship.
What about similar order? Appointment arbitrator. EYP. But Jamal, what do you let Samantha know? Let Samantha know. Huh? Check on Samantha last time. And move him to appoint arbitrator to order thing. Kenapa file pun check boleh movie level no? Oh, somebody mana?
35.
A supply copy.
No. It's a matter which is constantly there's already a standard. Check.
Please, your lordship. Lordship, this is an Akang matter, my lord. This is the second round of litigation before this honourable court, my lord.
Where's the GHDC?
He was here, my lord. No, where he went.
Yes.
So our contention, my lord.
Where's last order of this court?
It's at page 100, my lord. Annexure 10.
No, order of this court. This court.
Or this court, my lord.
Demanding by the matters.
Yeah, page
Page
20, my lord. Annex 2. Relevant portion at page 22, my lord.
Yes.
After the matter was remanded back, my lord, so we filed an application, and thereafter, my lord, suggested issues were also filed, my lord.
Before the in-charge land revenue?
Yes, my lord.
Then
the suggested issues was not taken on board, my lord, and he framed his own issues, my lord. Kindly come to page 82, my lord. Lordship comes to page 82, the last line, my lord. On going through the records, I have determined 3 points, important points, which are whether the claim of the petitioners has any concrete evidence to prove their claim of being the descendants of and lineage of Mimuk Sangma, and whether Mimuk Sangma is the recorded Nukma. Second, whether the Nukma recorded in the GT, that is Sanjang Marak and Manji Sangma, were from the lineage of Changre Sangma, recorded Nukma or not. Whether the procedure of taking no objection from Chas, Chachis and clans men was taken before appointing Sanjan Marak and Manji Sangma. Our contention is that, my lord, the predecessor of the respondent number 5, my lord, was from a different community, from a coach community, my lord. So that particular issue also was not
registered document.
Yes. So
why that was not framed?
That was not framed, my lord.
But how long ago was that predecessor interest?
Who was the grandmother of this private respondent, my lord?
Then how can you rake it up after how many years?
No, but the mother of the respondent also was not even registered, my lord. So I also was from the direct descendant of the undisputed recorded Nukma, my lord.
The last undisputed?
Undisputed, yes.
Okay. But the name of that coach person was recorded also?
Yes, was recorded.
There was no objection at that point in time?
There was no objection. Verbal objection was there, but of course that objection was not taken on board, my lord. And but we were continuing as the Nukma as well, my lord. But what happened was that the genesis of the matter was like, my lord, the predecessor, after his marriage to my great grandmother, my lord, she had an illicit affair with the coach person, my lord, and she managed to record her name in the genealogical tree, my lord. Thereafter, the people objected, the Chas and Maris objected, my lord, but the name was not. Of course, I do admit, my lord, there was no application to that effect before the concerned authority, but we continued as the Nukma, my lord. Thereafter, the daughter of the respondent, my lord, the predecessor of the respondent was the daughter of the coach. Her name also was not recorded, my lord. And when she wanted to register this respondent, my lord, we objected in the 2008. And the EM went in favor of the respondent, whereas CM went in our favor, my lord. After being aggrieved, they approached this honorable court, and this honorable court remanded back the matter.
To try afresh.
To try afresh, my lord. Because evidence and issues were not framed at that point of time. So, issues, of course, was framed, my lord, here. But the issues in point number 2 also is a false finding, my lord. Why I'm saying that? Because the evidence says otherwise, my lord. If lordship comes to page 83, paragraph 3 paragraph, my lord, in regards to determine point number 2.
Yeah.
I have gone through the records, written arguments and examination in chief in the form of affidavit and cross-examination. This court opines that the claim of OP number 1 is proof that she is the daughter of Dandri D. Sangma, which is false, my lord. It's a wrong finding. If I come to the evidence, my lord, Kindly come
the
to
coach person is then. What was her name?
the last undisputed
Coach person.
or was Changre Sangma, my lord.
See, in regards to the point of one to the recorded arguments also, the court opined that King Opinion 1 is approved. She is the daughter of Dandri Sang. Who Dandri?
That is the undisputed Nokma, my lord. Last
Who is the younger sister of Bajangma?
Dangre Sangma.
Both being the daughter of Changre. Now, Changre is a grandmother.
No.
Dandri
Changre is not the Changre is not the daughter. Why I'm saying that,
my lord? Written here. Upon the claim of it's proved she is the daughter of Dandri Sangma, who is the younger sister of Baki Sangma. Both being the daughter of Changre Sangma. Then?
No, that is what, my lord. If lordship goes to the evidence, it will be clear, my lord, that she is not the daughter of Dangre Sangma, my lord.
Who is the daughter of Dangre Sangma?
Daughter of Dangre Sangma is Mimic Sangma, my lord. The evidence will speak, my lord. It's on record. So if lordship comes firstly to the evidence, my lord, page 35. This was the evidence given by the plaintiff's petitioner's witnesses, my lord. Page 35, this is the type copy, my lord. If lordship comes to paragraph 3, I am party of this case in regards to Akang. If lordship has found it, my lord. Tobin Dungre Nukma Dombagri. I know the Mahambi, however, I don't remember the rest. Mimic Michik is the daughter of Dangre Michik. Mimic Michik is the granddaughter or is the daughter of Dangre Sama, who is the undisputed Nukma, my lord. And again, my lord, kindly come to page 41. I just want to establish first, my lord.
This coach lady, she was in which year was she entered the Nukma in the GT? When she was entered, you see, she was entered.
Yes, she was entered, man. Rightly or wrongly, yes, she was entered.
Undisputed after,
Yes.
I think, this.
Yes.
Which years were those?
That it's not mentioned in the record, my lord. Here, which year? But that is not disputed that her name was reflected, my lord, in the GT. So, firstly, I just wanted to establish, my lord, that that my predecessor is from the direct undisputed, from the lineage of the direct undisputed Nukma, my lord. Lordship has found page 30.
Lordship, Mr. Day,
My lord.
any idea when the
So, as per this document, page 18, annexure 1, my lord, we cannot ascertain that the original document is required to be placed, my lord.
No, where's her name here?
Her name, my lord.
Changre is here, Machiksi, Songchang Marak and Chandre Sangma.
Yes.
Changre Sangma. And after that was Benjing and Manji. And you
No, not Benjing, Sanjang Marak. Benji Marak could not be a Nukma because the mother of the
coach.
Yes, no, because the mother of Manji Di Sangma was not recorded as Nukma at that point of time, and her name is also not reflected.
Then who wrote by hand here?
This was on 22nd 12 2008. This probably has been done by the Registry Council. If I can just point out, my lord, Songji Marap is a male, my lord, not a female. Now,
Sanjay Marak, that is what it is not disputed, my lord.
And the other hand, where my friend is saying that she is a coach lady.
No, other side is not there.
No,
Sanjang Marak, yes.
was given Changri Sangma, Michik. Now, probably Songjong has died. Another man was given to her. Benjing Mara. Now, out
and how does his name
that is not the
here?
case, my lord.
Whose name?
Why does the name appear then after that again? Sanjang Marak. Sanjang Marak.
No, it is. No, just a minute, please. One is Seng Chang Marap. Another is Sang, S-A-N-G. San Jan Marap. It's not the same person, my lord. It's not the same person.
Changman. No,
yes.
Manjing Marak is the father of Manji Di Sangma, my lord.
Who?
Banjang Marak, whose name is recorded, my lord, after Sancheng, is the father of Manji Di Sangma. Is the father of Manji Di Sangma, my lord.
That I dispute. Probably cannot be correct.
No, it's
There is a
recorded,
father
it's
and daughter.
reflected here, my lord.
Father and daughter, my lord, their name cannot be entered. It is the husband and the wife's names has to be
No,
entered.
that is what I'm saying.
Let the
Manji's
record be
husband
called, my
is
lord.
recorded
I will
as
also examine.
Sanjang Marak, my lord. If lordship comes to the type copy, my lord.
See, Sanjang Marak is recorded as husband of Manji Di Sangma.
Yes.
Yes.
So Banjang Marak, if you see Banjang Marak, there's a space. So the mother should have been reflected here, but she was not recorded as Nokma at that point of time, my lord.
Then Manji is the daughter.
Yeah, Manji is the daughter.
How is it possible then the father and son recorded as Nokmas? Not possible.
No, after Changre, after Sanjang Marak and Changre Sangma died.
Not possible. That is not the system that they follow.
No, Banjang Sang Marak, my lord.
Now you are claiming your title from?
From Dangre Sangma.
Where is Dangre out here?
Here is Tobin Marak, Dangre.
I know, I can say Dingre or Dangre?
Dingre Sangma.
Dingre Sangma.
And Tobin Marak.
Now the question is this. My friend is claiming his successor from Dingre. Now if Dingre was supposed to be there and her daughter was supposed to be the next Nokma, from where Changre Sangma has come.
Exactly. That's the question. That's the question.
Changre,
You see, if you say you're a daughter of Dingre, right?
Yes.
Or granddaughter.
Granddaughter.
Then what happened to your mother?
My mother was alive at that point.
Is no one the
Mimit Sangma, my lord. It's there, it's recorded here, my lord. In the
Mimit's not there.
No, of course her name was not there, because that is what I'm saying, my lord. The genesis of the matter. Just hold on.
The thing is, so Mimit never staked any claim. She kept quiet.
No, she was there, my lord. No, what I mean to say was,
see what this court trying to say is whether you're trying to revive even a stale claim. You understand? Whether this one by lapse of time has become a stale claim or not. If you're trying to derive your whatever interest from Dingre, who came before this coach lady which alleged as Changre Sangma.
Yes.
Then whether you're trying to revive a stale claim.
No, even
if this is 2008, that means your predecessor interest, Dingre, must have been there in the 80s or 70s. Then
no, even if that be so, my lord, even the name of even the mother of Manji Sangma was never recorded, my lord, as Nokma. So she cannot be Nokma. Then the trust and Maharis has to decide as to who would be the Nokma.
No.
If she was the Nokma, my lord, then of course my claim would be stale, my lord.
You are the present Nokma.
Yes, I'm.
You come this side.
What's your name?
What is your name?
Manji. So Manji, you see is the daughter of Changra only?
No, she's the granddaughter
of Changre. So
yes.
She has no right.
Yes. No, because the mother also was not recorded as Nokma at any point of time. So if that be the case, then
and this Manji is recorded 2008.
2008 only.
25.
No, we objected to it, my lord. When the matter came up before this honorable court as well.
So now you agree with, you say that the issue is not framed properly as to whether that Changre was a coach.
Even the evidence also was not taken, my lord, into consideration, because the evidence also says that Manji Di Sangma.
How do you say it was not taken properly?
No, I'll come to that, my lord. Lordship is patient enough to just go through the evidence part, my lord. I'll just try to make my point that
see,
Manji.
Come to page 84. See, read the last paragraph, main paragraph there.
After determining all the three basic points, it is found that Sanjang Marak has point.
Yes.
And Manji Sangma, granddaughter of Changre Sangma and daughter of Dandri Sangma. This is the daughter of Malo, Dandri Sangma, never recorded as Nokma. So if she's not recorded as Nokma, how can they become a Nokma, my lord? If I am having a stale claim, my lord, if Dangri was recorded as Nokma, then of course I would have said, my lord. But Dangri was never recorded as Nokma. Is the best person entitled to be Nokma of Dombagre Akang, and accordingly I have appointed Sanjang and Manji Sangma as Nokma of Dombagre, without any kind of doubts. And they shall continue to be Nokma of this said Akang land as per the previous order of the then executive member. Previous of the executive member, that was already set aside by this honorable court, my lord. It was remanded back. Those orders were already set aside.
And even after adjudicating the case, after trial remains the same. Anyway, that there's no quarrel about that. If I pass the same order, that Sanjay Mara only would
Yes.
have been a Lokmas.
This is like trying to upheld the whole executive member order, my lord.
Very difficult to revise your claim.
So, if there's a dispute, my lord,
This is a.
the Chas and Maharis will be the best person to appoint a Nukma, my lord, in this kind of situation.
Will lead to more confusion.
The confusion is that now they are trying to claim that the Akang is a coach Akang, my lord, where it is a not a disputed, my lord.
First time Manji came with Sanjang, right?
Yes.
Before the court, 2014.
Yes.
Correct. Then they were sent back for fresh trial.
Yes.
Then took evidence and they said that no, like this is a thing. There's order of the deputy CM in charge, and this is upheld also by the CM.
CM, yes.
Correct. Yes.
The evidence part also was not taken into consideration, my lord. That is my grievance as well. No, I'll just take. I'll not take to the evidence part of my witnesses, my lord. I'll just come to the evidence part of their witnesses directly, my lord. Lordship comes to page 60. That is their witnesses.
They admit there's a coach.
Yes, they admit, my lord. If Lordship comes to page 60, second paragraph, or third paragraph, my lord. I knew Singchang Marak, page 60, my lord.
Yeah.
I knew Singchang Marak. Changre Sangma is the first wife of Singchang Marak. Singchang, Changre's father is Tobin. It is not a fact that Mimik is the wife of Singchang Marak. It is a fact that Changre's mother is Coach and father's name is Soban Marak. They've admitted here. And in other,
Whose statement is this? Who's this Nick Johnson?
this is
Marak, sorry.
This is their witnesses, my lord. Nikchang Marak. This is their witnesses. And please come to page 64.
See what kind of case you're making out, whether it deserves any, further consideration. That's why I'm asking you, to trace the lineage, and whether now evidence you say the first one was Siramara. I know one is
my lineage. If Lordship wants to be clear, my lineage, my lord. I have my lord.
You brought a family tree.
Yes, in my rejoinder, my lord. Paragraph 5.
Which one is
rejoinder to the affidavit of opposition filed by respondent 5, my lord, which was filed on 22nd July.
Yes.
Paragraph 5, my lord.
Yes.
That in regard to the statements made in paragraph number 7, answering deponent begs to submit that after the demise of the recorded and undisputed Nokma, Dingre Sangma and late Tobin Marak, the daughter, late Mimik Sangma, became the default Nokma of Dombagre, Akang, being the only child. Mimik Sangma, along with late Singchang Marak, has also one issue, namely Sanjay Sangma, who had 8 issues, namely Chikman Sangma, Tikman, Chingan Sangma, Malgan Sangma, Sinje, Nikje, Galje, and Walje Sangma. The Chas and Maris later appointed Walje as Nokma daughter, who would have to become the rightful successor to be the Nokma of Dombagre. After that, the Nokma's successor, Walje Sangma and husband, Pilsa Marak, had 6 issues, namely Wana Sangma, Akang Sangma, Dumje, out of which Wana Sangma became the Nokma daughter, my lord.
The present petitioner.
Yes, the present petitioner. This is my lineage, my lord. They have also admitted that, my lord, in their evidence. They have also admitted the fact that the grandmother was from a Koch community, and that the.
Where is that? I haven't seen that anyway. But today the day to unravel. Can you get the years when that
original record has to be called, my lord? Moreover, my lord, if I can point out, my lord, if we go back to the genealogical tree, annexure 1, my lord, it is impossible, my lord, that a coach lady will insert her name directly. Moreover, my lord, we can see.
It's not impossible before district council, my lord. I'm telling you.
That, my lord, my friend may have any opinion about district council, but he's governed by district council, my lord, only. So, what I'm saying is this, my lord. Sengchang Mara was given this lady, Chengri Sangma, my lord. Otherwise, they would have entered her name as coach, my lord, not as Sangma. And moreover, my lord, when a Mahari give the, please let me complete. Mahari give the wife, my lord, it will definitely come from the lineage of the wife, my lord. It cannot go beyond.
That is what, see, that's what the school trying to understand. Now, how does he establish his claim? Where is the material evidence or whatever the position that's here that clearly establishes that this lady Changre was a coach?
Exactly. And second
his
thing,
whole claims on that.
And second thing,
he said that she is a coach, that the granddaughter, this
Yes.
mimic, she's not
I will
because
play
she
my
draws her lineage from a coach lady.
I will play,
and whereas she is the rightful successor because
moreover,
of
my
being,
lord,
yes.
Moreover, my lord, now 16
belong to
years,
the-
16
that
years
much
in
of-
district council, my lord, I have seen. Sometime the
60
grandmother,
years?
16, 1-6, my lord. Sometime, my lord, the grandmother name is inserted in the GT, my lord. Subsequently, my lord, the daughter doesn't come into play, but the granddaughter comes in claim, my lord. There's no wrong that he is saying, my friend is saying that the mother name is missing. Then the granddaughter cannot claim. That is not a correct proposition of Garo customary law, my lord. The granddaughter can come, my lord. If in the lifetime of the grandmother, she want to give it to the granddaughter, she can give, my lord. And now what my friend is also submitting, it is the Mahari who will decide who will become the Nokma. With due respect to him, my lord, the first choice is given to the Nokma, the Nokma who was sitting there, my lord, who will succeed her, my lord. It is not the Mahari. In the absence of the male and female Nokma, then only the Mahari come to play, my lord.
No, my lord.
That is the law, my lord.
I'll place it, my lord. If that is this argument, my lord, I'll place it, my lord.
That is the law. That is the law of the division bench of this honorable court. Chalis Sangma, my lord. But Mr. Paul has argued, I was also a party to that, my lord. I can place the law tomorrow itself, my lord. Chalis Sangma.
It depends on the mother and father, my lord.
The first threshold first, whether there's any relative evidence to show that this Chingre was.
No, that's what I'm trying to show it, my lord. If lordship is kind enough to just go through the evidence part.
I'm saying that firstly, Saljang was married to a Garu lady, then he took Chingre as a wife, and somehow she inserted her name, got it in the GT, and so from there the daughter became the daughter didn't become, but the daughter
didn't become.
Granddaughter became the Nokma. And so he's trying to establish his claim. So we're just trying to understand, how in which manner was it inserted, whether what happened to the original wife.
The original wife was there, my lord.
The Mahari didn't do anything at that point of time. If that had happened, and if the substitute wife was given also by the Mahari, suppose for whatever reason,
she was not a substitute wife also, my lord. He was still alive at that point of time. What happened was he deserted the Akang and got married to this coach lady and got her name inserted in the GT, my
if he
lord.
deserted, he's out of the Akang.
Yes.
How that's Garu custom? How is out?
That is what, but the name is there recorded in the GT, my lord. That is why.
You can't suppose you are married to a Nokma or whatever, that you become a Nokma together with your wife, correct? Suppose you leave. Many cases are there. He leaves.
Yes, but he got his name inserted in the GT, my lord. That is the problem.
How can you correct that now, Mr.?
I'm not going to correct that, my lord, and I'm not asking to correct that part, my lord. But so far as this respondent is concerned, my lord, she cannot be the Nukma.
That is what is established, that is the thing. You're not trying to correct that, that means mimic.
No, that is what, my lord. Here in the defense witnesses only, they themselves, they are saying that Changre's mother is coach. They have stated here multiple times. In most of the evidence also, most of the witnesses, they have stated that the mother is the coach and the Akang belongs to the Dopo Toteng Abing clan, my lord. So if that be the case, my lord, then where the Chas and Maharis will be in their favor or will be in my favor, my lord. And the best person to ascertain was the deputy CM to see whether the Chas and Maharis.
That when they took this matter up, they didn't frame the issue on this.
No, they didn't frame the issues all this, my lord.
Whether she was a coach or not.
And moreover, my lord, in the evidence itself, they are saying that it's a coach. The grandmother was the coach from the coach community, my lord. That was a clear.
Clinching, you mean that,
yes.
that's a clinching issue in your favor.
Yes, and moreover, the mother also was never recorded as Nukma at that point of time.
Now, is Chingre's mother still alive? A daughter, sorry.
No, that daughter also is not alive anymore, my lord.
What is the granddaughter now, the Nukma?
The granddaughter, yes, she became the Nukma.
Mr. P.T. Samba, you're keeping quiet. What do you have to say? Are you a descendant of Coach Lady or?
Lordship, as for the GT and also the from the order of the Deputy CEM, it's very clear, Your Lordship.
No, I'm not doing it all. This is from your own submission.
Because we are
Is it correct submission that your grandfather took, he deserted and inserted
no,
your grandmother's name?
Correct. It's not correct.
How have you refuted that?
Yes, we have.
I
have clearly mentioned in my RPDP in opposition also.
What have you said?
They're claiming that first they claim that this particular Akung was acquired by the Siala Marak Brong Duchi, but the Dupototung. That we have stated that Tubun Marak Demri Sama Michik also been appointed as Nukma, but only in 10 generations, counting from the first recorded Nukma, and thereafter Nukmaship has been acquired by Sing Chang, Marak, Chingri, Sangma, Michik. Nowhere in the Mambi show any lineage in regards to Mimic Sangma. So they are claiming from the lineage, and lineage has never been entered even as a Nukma. Even
no, your case is that mimics a stranger to the entire.
Yes, that is their claim. They are saying that they are the lineage of the Mimic, whereas Mimic has never been recorded in the GT. Nowhere it is mentioned, neither in the evidence, nothing has been. So they are just a mere statement. I have made it very clear in my RPDP to the opposition. Mimic has even somewhere in the Deputy CM also has passed an order that Mimic has neither the lineage of the first recorded Nukma, nor he was ever registered as a Nukma of that. The Mimic Sangma. That is their claim. They're saying that there is their lineage of Mimic Sangma. So I have stated in my RPDP in opposition that the para page 3, my lord. So even in the
where is he affidavit?
Yes, Lordship.
It's getting very confusing. Yes.
I think it's a petitioner who is making confusion, because from the record, there was a court order was there that this matter was remanded by this honorable court only to frame issue. That issue has been framed detailedly. All the examination, the witness has been recorded. They were examined, and then after recording all the statement, giving an opportunity, full opportunities, then there was a finding. So only they're saying is that there was a same finding prior to the order, earlier order. It is a similar. Therefore, they're saying that is which is.
You're Manji.
Yes.
You're
I'm
Manji. Yes.
So we are saying that we are the lineage of from the first recorded Nukma till date.
From Thinsey?
Yes, Lordship.
That is false, my lord. Because
it's easy to say.
No, because
fault if you can't show materials.
The evidence I'm showing, my lord. In the evidence, the witnesses they themselves, they're saying their witnesses, not my witnesses. My witnesses, of course, they're saying their witnesses also. They're saying that the grandmother, Changre's mother, was from a coach community. I've showed you, my lord. Here also another witness, their witness, page 68, my lord. Lordship comes to page 68.
You bring the record.
I'll bring the record. They'll come after 2 weeks.
Let us examine.
Page 68, just for perusal, my lord. Lordship comes to page 68. No, it's in English. The witnesses were recorded in English, my lord.
What about a party?
Page 68.
They're not recorded of mine. This is by who? Statement by who's this? One second.
This statement by Niching Marak.
Niching Marak.
Yes.
Page?
Page 68.
60.
Tombagre Akhang belongs to Dopo Toten. I don't know that since when the Akhang was existent. I know both the parties, Mosda spot inquiry, but I don't remember the date. I know Pigeon and Kochi. Pigeon and Kochi were the parents of Changre Marak.
See? Then?
It's Koch, my lord. There's written Pigeon and Koch. Were parents of Changre Marak. It is not a fact, and they were not recorded Nokma. I do not know mimic magic.
I don't know mimic magic.
Yes.
It's not a fact that mimic is not.
It's not the wife of Sikchan.
Yes, then?
Then it's a wife of Sikchan, my lord. It's not disputing also.
It's not a fact, mimic is not the wife. Okay. Double negative.
Yes. Dingre, daughter of Dingre. Undisputed Nokma, my lord. It's their statement. The statement of the witnesses should have been taken into consideration, my lord.
It's not a fact that Chengri is not the Jin. How does this mean? In other words, see, I know Tobin, it's not a fact, mimic is not the daughter of the. It is not a fact that Changri is not the Jik Nokol of Seng Chang, meaning?
Jik Nokol is like the second wife, my lord. Lily said.
She is the second wife.
Yes.
Now, my lord, may kindly come to the next one.
I think that troubles his code. How can a person insert a self? Because you leave, you're out from the thing.
Now, my lord, may kindly come to the next line.
They did it, my lord.
Parlance will be out.
Out?
No, of course, yes. Then, normal parlance will be out. But now, if they are out, but they're still claiming.
Into your wife's account and say that, you know, that she'll be the.
No, we were continuing as the Nokma, my lord. No, but only in the record, her name was reflected. That is the difficulty, my lord.
May kindly come to the next line. That is very important. It is not a fact that Changre is not belong to so and so. A king.
Yes. This is contradictory.
Yes. Can this evidence be relied on, my lord?
See, and then Wana is also from Dombagre. You are the petitioner.
Yes.
And belongs to the same clan as that of Changre.
Yes.
Changre's one daughter, Manje. I know Wana. So Manje is, what's it, Manje's mother.
Again, by the brother. The brother is also saying that Changre do not belong to Dopo Abing.
So can this evidence be relied on?
That if your evidence is not relied on, why did you take consideration of this evidence and pass an order in their favor? If that be the case, my lord, if he's saying that this evidence cannot be relied upon, my lord.
On one hand, Mr. Momin is saying the evidence has not been relied upon or wrongly relied upon. On the other hand, he's saying that why we have done it. First, he has to correct himself, my lord, whether his case is that we have taken wrong evidence or he is not we should not have considered this evidence. Now, he has to be very clear on that.
Okay. Very interesting. The first case I've come across in all these cases that, you know, insertion of
no, insertion of Nokma has been there, my lord. No, it has been there, my lord.
Insertion of a.
It cannot be allowed.
From a coach committee, yes. From different.
No, it will never be allowed, my lord.
It has been allowed, my lord. That is why we are before this honorable court, or else we would have not been here, my lord.
It's impossible. I have never.
Maybe not
this,
ever, but now you are hearing this case.
Because this Aking is so emotional for the Maharis. They will never allow. They will go all out.
That is why it was recorded. But so long we have been administering as the Nokma, my lord.
Correct. It's a very, you know, it's a very, what do you call it, it's central to the entire system. I mean, you can't have you can understand if, you know.
And moreover.
See, now in this kind of cases, my lord, if suppose
different machong or whatever, you know, then you dispute what they do.
Then the main
you say the total outsider,
yes,
inserted by the Nokma who's left his wife. Now she can take the husband, then they'll be joint Nokmas. How can he come and insert his wife who's come to the coach and they become recorded as Nokmas? How did he manage?
And interestingly, it is not written coach in the GT. If it is written
no, I could have said, never be, my lord. If they have done it illegally, why will they record it as a coach committee? It should be an outsider. After all, if it is recorded like that, my lord, from prima facie, it will be evident that she's from different community. If it is recorded in the GT, they have never done it like that. Even in joint Nokmas.
She belonged to Domba Akang.
She belonged to Domba King, that is also there. And moreover, it is not coach they have written, Kochi. What does it mean? We don't know.
Kochi, we know, my lord. That is why we're saying Kochi means coach only, my lord. There's no other committee by the name Kochi.
It may be a nickname also, my lord. That is why record will be required, my lord, to examine.
But there are records also, but that point level.
That point, yes. That entry, when it was entered, that is very important.
The best thing would have been, my lord.
A claim or not, you very have a steel claim.
No, the best thing would have been, my lord. They could have taken evidence from the direct descendants, my lord.
You see, from now you can revert back everything. All the Maharis now know what they do from before. They are all gone, probably.
No, they'll be knowing, my lord. Some of the old Maharis will still be there, my lord. And some of the neighboring villages also. Neighboring villages also, they'll be there, my lord. Still there.
Anyway, I was hearing it was the first time I've heard a case. He was at the Dompo clan. Both of them belong to Dompo clan.
Now they are saying Dompo clan, but no, our contention is that they are from Koch community, my lord.
That is why no one objected at that
point of time.
Manji has been since 2008.
Yes.
Now is a lifetime. 33 years, 34 years.
But the mother was never recorded, my lord, as the Nokma.
Doesn't matter.
That doesn't matter.
Manji has already been recorded as Nokma, my lord. We are not.
There's many cases we skip also. But even the fact that she claims from Shangri, that means that she feels she's confident about her birthright, whatever.
I'll please
you
that
get
record.
you the record. We'll just examine it. Whether at that time of entrance in the
Yes, my lord. And moreover, Mr. Sangma can also produce. Chengre
we want all the years.
No, they issue certificate.
We'll look at the years. If it's long gone, we will not entertain the matter. We won't. I'm not thinking of remanding it back. That's why.
My lord, I will get the order sheet. Probably in the order sheet it will be.
And some orders also, my lord, it will be required. That all orders, my lord.
Relevant orders, yes.
Yes.
In the course of hearing, it appears that records of this case missing.
It may be very specific. The date when Changri's name was entered in the GT. If my lord reflect that, I can.
Yes, from the records, especially the date on which take down Changre SCHNGRE Sangma Michik was entered in the GT records.
GT record.
Together with husband Sengchang SENGCHANG Marak. So, any other relevant materials also may be produced by the Learned Council. Yes. Just after 2 weeks.
38.
My lord, this is the regularization matter, my lord, Nehu. The only objections two objections rather, my lord, that they have said is that we were not appointed against a sanction post, number one, that. And there were other petitioners who were before this honorable court and whose prayer for regularizations were rejected, my lord. And I have an answer to that because those petitions, those cases were not judgment in rem, my lord. That was judgment in personal. They were those people who came before my lord earlier rounds. They had a break in the services, my lord. So our members stands a different footing, my lord, altogether. My lord, I'll just like to place before I.
Where's Mr. Sen? He's outside.
Yes. I like to place this Jago, my lord, the case of Jago.
Jago, you're playing Jago all the time.
My lord, Uma Devi, I used to place, my lord. Jago is the first time I'm placing now, my lord. The service jurisprudence has changed completely, my lord, after Jago now.
In one court.
Oh, my lord.
Yes.
So now, my lord, just take to the writ petition, my lord.
Yes, see, what are your facts?
The facts, my lord.
This person represents them also, he's a worker.
I'm sorry, my lord.
This person represents them. He's also
my lord, he is the president of, because this is a, this association, yes, my lord, it's a union, my lord. It's a union. And he is, of course, my lord, he is a president of the union, my lord, of the workers' union, my lord, and he's not an employee of the Northeastern University, my lord. So he is a president and he is espousing the cost of his members, my lord. Not for himself, my lord, for his members. My lord, My lord, may come to annexed.
How many workers are in consideration here for regularization?
My lord, will paragraph 3, my lord, can you have paragraph 3 of the writ petition, my lord? The members of the union falls under the categories of non-teaching group C. They are further categorized as unskilled, my lord, 140 numbers, semi-skilled 8 numbers, skilled 60, unskilled.
That means they are peons.
Peons, safaiwala, kitchen attendant, and so forth, my lord.
Yes.
And then you have semi-skilled, my lord, that is 88 in numbers, and we have skilled, my lord, 60 in numbers, my lord. Highly skilled, my lord, 8 in numbers. So this many employees, my lord, are before my lord. This and my lord, and all of
40 plus 8 plus 60 plus 8
plus 8, yes, my lord.
Okay.
So my lord, and all of them,
16.
yes, my lord, and all of them, my lord, have served more than, my lord, more than a decade, my lord. 15 to some even went to the extent of 20 years also, my lord.
Yes.
So my lord, the objection that they've raised was that we were not appointed on a sanction post. Now the RTI reply, my lord, is at page my lord, will come to at page 28. Page 28, my lord. Escort, my lord. Page 29 is a typed copy, my lord. Page 29. May I read page 29, my lord? Information under RTI. With reference to the subject mentioned above, please find herewith the information sought for by Shri so and so, my lord. Question number 1. What is the total number of vacant posts under Group B as of current date? Reply is 24 posts. What is the total number of vacant posts under Group C as on current date? 185 posts. Please provide the names of all the vacant posts under Group B. Please also provide the names of all the vacant posts under Group C. Reply is Group B, my lord, section officer, private so and so. Group C, my lord, upper divisional clerk, lower divisional clerk, so and so, or plumber. These are the post name, my lord. Then again we say that what is the total number of sanction posts available under Group B? They said 122 posts. What is the total number of sanction posts available under Group C? That is 401 posts. What is the current number of regular staff employed under Group B? That is 63. What is the current number of regular staff employed under Group C? That is 183, my lord. Now, if my lord will see, .401 is the total sanction post.
Group C.
Yes, my lord. And 180 posts have been occupied by regular staff. And our members occupy 201 posts. And still there is
ample space for them.
There is ample space. So therefore, my lord,
post rather.
Ample post, my lord. So therefore, the only objection that they've raised, that we are not appointed at a vacant post, my lord, has no legs to stand, my lord, here. So that is one point, my lord. Now, so far as and my lord, they have never, we have been appointed right from the inception, whichever employees, respective employees were appointed, my lord, there is no break. We have been continuously occupying, my lord, doing the essential service, essential work of the university, my lord. And there is no adverse remarks against any of the members of my association also, my lord. We have continued to work, my lord, for 10 to 26 years. Those who came before this honorable court for regularization, my lord, they stand on a different footing. Why? Because they had an appointment and there was a break. There was a break. That is the reason why there was a break. That is the reason why the regularization was.
What are the terms of engagement?
We were appointed some on terms of the engagement.
Sample, yeah.
My lord, that sample is not there.
Dr. Mr. Sen, what are the terms of engagement? Daily wage,
It has to be daily wage.
Casual.
Casual, my lord. Casual.
Where?
If your lordship comes to page 4, so my lord, paragraph 4.
No, term engagement. How about term engagement? So there is free. Where all your
My lord, these are not against sanction posts, my lord. These will depend on my lord, availability of work.
all the rights will flow from the initial whatever kind of engagement.
Lordship.
They have. Correct. So the thing. So whether you want to see that, what is the term of engagement? As per your records, what was the term? Have you put an affidavit?
Affidavit, my lord, I have not annexed any document, but I have made the statement. Paragraph 4 onwards. Lordship. If I can read my lord, paragraph 4 of our affidavit. That with regard to the statement made in paragraph, it is specifically denied that not registering and illegality and arbitrary has been committed. There has been in principle of natural justice ratio laid down by the various court in the various judgments. In fact, the numbers of the unions are working as casual workers are not eligible to be regularized under law. Many casual workers in the university have either individually or collectively approached this honorable court seeking regularization of their services, and this honorable court, after hearing the parties and examination of record, rejected such bail. The reference of these cases would be set out in the subsequent paragraphs. Now, my lords, there were a number of cases were filed, my lord, by the casual workers. And I believe, my lord, many of those casual workers, again, the members of the associations. And these matters, my lord, traveled up to the division bench. And in fact, my lord, I don't know, the judgment division bench say, why the same issue are raking up again and again? Please don't bring this issue. Why is that?
Because Mr. Yobin is saying that
yes,
it's not based on the same premise.
My lord, no. Our as per the records, my lord.
That's why, see, one thing,
yes, my
Mr.
lord.
Yobin, is that petition is so brief.
My lord.
Bereft from any specifics,
My lord.
difficult for the court to, by just making a broad statement that there's no break.
My lord, that fact has not been disputed them also. My lord, there was break or not break, my lord.
Fact, correct.
Yes. And my lord, paragraph, my lord, just one more point I like to submit, my lord. If my lord will come to page 34, my lord, this is an acknowledgement. Page 34.
The affidavit.
Of my writ petition, my lord. Page annexure 4. This is a memorandum of settlement, my lord, executed between the union and the respondents, my lord. So this is an acknowledgement. My lord, may I read? Memorandum of settlement and arrive under section 12(3) of the Industrial Disputes Act. So before the Regional Labour Commissioner, Guwahati, at Office of the Deputy Chief Labour Commissioner, Kendra Sharam, so and so, Nehu. Parties, the Registrar Nehu, represented by so and so.
Where are you reading from?
My lord, page 32, my lord has got.
32.
Page 32, my lord, NHF 4.
Yes.
So, this is a memorandum of settlement, my lord. This was settled between the parties, my lord. Short recital of the case, we can go from there. The present industrial dispute has been filed by the union seeking implementation of the DOPT number so and so in respect of 322 numbers of casual workers in Shillong campus, out of which 244 casual workers are associated with the present union and 39 casual workers in Tura campus. The present industrial dispute bearing number so and so was seized into conciliation, and after receiving of the said file by the RLC from ALC, Guwahati, notices were issued to the parties to the dispute and jointly meetings were held, and finally on 29/05/2023, the union in a representation dispute mentioned that Northeastern University employed 361 numbers of casual workers working under its Shillong and Tura campus, but has failed to implement the provisions of the DOPT number so and so, which was inter alia stated. Where the nature of work entrusted to the casual workers and regular employees is the same, the casual workers may be paid at the rate of 1/30th of the pay at the minimum of relevant pay scale plus DA for work of 8 hours a day. In case where the work done by a casual worker is different from the work done by the regular employee, the casual worker may be paid only the minimum wages notified by the Ministry of Labour so and so, which is higher than a wage. The matter has been discussed in details in an amicable environment, and with the persuasion of the conciliation officer, the parties to the dispute has agreed for a settlement on with the following terms and condition. Now, the management agrees to implement the OM in full spirit and in toto. The management agrees for fixation of pay in respect of casual workers for both Shillong and campus as per the formula 1/30th of the pay at minimum the relevant pay so and so 8 hours a day. So, the payment of the casual workers may be restricted on the day on to the days to which they actually perform duty under the government with a paid weekly off or 2 days weekly off, as the case may be depending upon the working days of NEHU. The workman will however be paid for notional holiday if it falls on the working day in addition to the weekly off. The union agrees for payment of arrears or recovery of overpayment made to or from the workman based on so and so, my lord. So this settlement, my lord, has been arrived, my lord. This is an
what right did they arrive from settlement?
No, what I want to say, this is an acknowledgement, my lord. Acknowledgement that.
But whether casual employee is entitled to automatic regularization,
my lord, then
that's how you have to make out a case.
No, then I have to come, because this is what I'm trying to show is that there's an
No, you know,
yes.
doubting that.
Yes.
Only thing is that your casual employee, fine.
Yes.
But then, like, what vested right have you acquired by being casual employee? You consider regulation against the present sanctioned Group C post. That's all.
Yes. The vested interest that I have acquired over the elapsed of time, my lord, that more than 10 to 26 years of my regular service for them in the essential service, my lord, that has given me my vested right to be regularized, my lord. This is what the Jago said also. That is why I'm coming back to that
then
also.
Is it to the same post because semi-skilled, that's Group C, right?
Yes, my lord.
That means they're peon. So what particular post are you 201 people serving against? How many are serving as peons? How many are serving as whatever these helpers and
yes, my lord. That
the chart is there.
The chart, my lord.
Of your all the members and what are the nature of duties?
Yes, my lord. The chart is. The chart is at page 21, my lord. Page 21 to page 25. This is the chart, my lord. List of casual workers from NEHU for fulfilling regularization, my lord.
What duties are doing is there?
Yes, my lord. My lord. For example, number one is Prabhakar Singh, my lord. He is a senior technical assistant in the Department of Law, my lord, and he has.
But he is Group B.
Joint deep, my lord.
He'll come to Group B. Library assistant, driver.
Yes, my lord. ST nurse. These are the skilled. These are the skilled people, my lord. These are skilled. So we have all clubbed together here, my lord. And then my lord will see then ST nurse. Then Rameshwar onwards, my lord. Mali, carpenter, dresser, my lord.
All the members are given here.
All the members here, my lord.
Where's it? 210.
210, my lord.
200 and 196, yeah. 196, 200.
Yes, my 201, my lord. 201.
Yes.
So, my lord, all of them, my lord. Now, just to reiterate myself, my lord, all of them over the period of time that they have served, my lord, in this essential, my lord, services, and my lord, I have shown, my lord, how many posts are there, my lord, through RTI, and in spite of this, my lord, there are still so many vacancies are still there, my lord. So, which means that they are already occupying a sanctioned post. So, therefore, my lord, the saying that they are not occupying a sanctioned post, my lord, that is factually incorrect. Yes, my lord, that's factually incorrect.
The nature of duties are such that continuing.
Yes, my lord. Now, my lord, this in this case, my lord, the factual aspect is this much only, my lord. Now, let us come to the low point, my lord. In the Jago, my lord, whether I fall, can I derive the benefit of Jago's case? My lord, paragraph 8 of the Jago's case, my lord, can we have a look at paragraph? This is what was submitted, my lord, on behalf of the employees, my lord. Number one was submitted continuous and substantive engagement. The appellants emphasized their long uninterrupted service spanning well over a decade and in some instances exceeding 2 decades. They argue that Their duties were neither sporadic or project-based, but permanent and integral to the daily functioning of the respondent's office. That is exactly my case also here, my lord. We were not appointed on a project or a sporadic incidences, my lord. We were appointed for performing an integral and essential daily functioning of the university, and we have worked for without a gap for over a decades, my lord. The nature of the duties, my lord, that also same, my lord. The responsibilities such as cleaning, dusting, gardening, my lord, all this also comes to us. The absence of performance issues. None of my members have received any kind of show cause notice saying that we are dissatisfied.
These are contentions.
Yes, these are the contention.
Yeah,
Now, my lord, the contention of the respondents, my lord, at paragraph 9, this is exactly what Northeastern Hill University is also standing today, my lord. Then now, my lord, from paragraph 10, this is important with the observations of the court, my lord. Having given careful consideration to the submissions advanced and the materials on record, we find that the appellant's long and uninterrupted service for periods exceeding well beyond 10 years cannot be brushed aside merely by labeling the initial appointments as part-time or contractual. The essence of their employment must be considered in the light of the sustained contribution and integral nature of the work, and the fact that no evidence suggests that the entry was through an illegal or surreptitious route. That is also not the case, my lord. Number 11, the appellants throughout their tenure were engaged in performing essential duties that were indispensable to the day-to-day functioning of the Office of the Central Water Commission. Applicants number 1, 2, and 3 as Safaiwalas were responsible for maintaining hygiene. We can skip this, my lord. Then 12, my lord. Despite being labeled as part-time workers, the appellants perform these essential tasks on a daily and continuous basis over extensive period ranging from over a decade to nearly 2 decades. Their engagement was not sporadic or temporary in nature. Instead, was recurrent, regular, and akin to the responsibilities typically associated with sanction posts. Moreover, the respondents did not engage any other personnel to these tasks during the appellant's tenure, underscoring the indispensable nature of the work. The claim of the respondents, so this all, my lord, these are claims again, my lord. By saying this, my lord, finally, my lord, 12, 13, 19, 20. Well, all these paragraph 14, 15, 16, 17, 18, these are all important, my lord. But this has reiteration again, my lord. So we can come to paragraph 19. 19 also, my lord, that's the submissions, my lord. My lord, and the concluding part, my lord. 25, my lord. 25, we can come from this. It is disconcerting reality that temporary employees, particularly in government institutions, often face multifaceted forms of exploitation. While the foundational purpose of temporary contracts have been to address short-term or seasonal needs, they have increasingly become a mechanism to evade long-term obligations to employees. These practices manifestly in several ways: misuse of temporary labels. Employees engaged for work that is essential, recurring, and integral to the functioning of an institution are often labeled as temporary or contractual. Even when the roles mirror those of regular employees, such misclassification deprives workers of the dignity, security, and benefits that regular employees are entitled to despite performing identical tasks. Arbitrary termination. Temporary employees are frequently dismissed without cause or notice, as seen in the present case. This practice undermines the principles of natural justice and subjects workers to a state of constant insecurity regardless of the quality or duration of the services. Lack of career progression, so using outsourcing as shield, my lord, denial of basic rights, and so. Now paragraph 26, my lord. While the judgment in Uma Devi Supra sought to curtail the practice of backdoor entries.
Okay, Mr. Stan, what do you have to say?
My lord.
My lord, this is a case, number one, lordship, as we have stated very categorically, my lord, the appointment is not against the sanction post. They are casual workers, my lord, depending on the availability of work. But it is a fact they have continued. Secondly, my lord, as I have pointed out, my lord, similarly situated persons, my lord, I don't know, my lord, the same maybe the member here, also your lordships. Now, they have approached this honorable court. These honorable court, my lord, after detailed hearing, my lord, almost around 20-22 of them, your lordships. After detailed hearing, my lord, we haven't brought that guilty. My lord, if your lordship comes to paragraph 9, my lord, of my affidavit, I have categorically mentioned those facts. If I can just read it, my lord, paragraph 9. Start at page 7 of my affidavit. Yeah, my lord. That with regards to the ground made in paragraph 6.16.3, the writ petition, the deponent reiterates that the casual workers petitioner union have been engaged on daily wage basis, not against any sanction post, and their engagement was without following any recruitment process. Now, my lord, my learned friend, my lord, that Jaguar judgment, most of the judgment, there one thing Supreme Court was sure, my lord, that initial entry was through some selection. There was some semblance of, my lord, selection. Here, my lord, no selections. No selection at all, your lordships. Engagement without following any recruitment process of public employment, as such, are neither eligible nor entitled to be considered for regularization against any Group B, Group C sanctioned vacant post. The casual worker engaged by the university have been duly granted their entitlement, including EPF, ESI contributions, but their legitimate expression, which is not permitted by law, cannot be considered by the university. It would be pertinent to mention herein that several casual workers similarly situated as members of the union in the present case either individually or collectively approached these honorable courts seeking regularization of their services against sanction post in terms of Umadevi's judgment. These writ petitions were registered as WPC number such and such, such and such. This honorable court, after detailed hearing and on perusal of the relevant records, rejected the prayer for regularization by judgment and order dated 3/5/2013 and common judgment and order dated 23/10/2019. Some of the casual workers, being aggrieved, preferred writ appeals against the rejection of their prayer for regularization, but same were subsequently withdrawn and other disposed of by order dated such and such. Thus, the decision of this honorable court pertaining to regularization of casual workers have attained finality, and the petitioner union cannot reopen the same. Further, the ratio of the decision.
Let's see the judgment. We not carried it.
My lord, sorry.
Mr. Yubin.
My lord, those judgments, my lord,
these are reported judgments.
I can, my lord, which this,
there are two judgments. WPC number.
Judgments relevant.
My lord, I thought I have in my.
Don't carry it on to one's helpful to you.
Oh, my lord.
One is 113 of 2011.
No, you bring it.
My lord.
We'll continue, yes.
My lord.
When? We'll continue when?
My lord, day after, if my lord, day after, my lord.
Yes, ma'am. I'll bring my lord. I'm sorry, your lordship. No, I apologize.
We are bound. If we're not. Only that's the only thing.
My lord.
The issue is not really
Our stand is, my lord, this has attained finality, your lordships. This issue has already been decided. Can it be reopened? And in one of the judgment, my lord, I think that's initially by the Meghalaya High Court. They have referred to as many as 22 judgments of Supreme Court. I'll just place that.
But those judgment is bench, man.
Those are
not this bench.
Those are before Jago. Those are all cases Jago. After Jago, things have changed.
It depends on the mode. You see, all your right flows from your initial the nature and manner.
Because in Jago
also examine that only.
No, even in Jago, my lord, we just examine, my lord. It's not that there was an interview, there was a recruitment process. Nothing was there, my lord. It was on a neat basis only, my lord. The exigencies of the situation.
Yes.
What do you want?
Obliged, lordship.
Yes. Yes.
What do you want?
May I, my lords?
What's it for today?
No, it's for final disposal, my lords.
No, what's it for today? What's the matter? What's the is only pending writ petition now or the others?
This is the only pending writ petition.
Only pending one.
Yes, my lords. Only pending.
Yes.
But now, my lord, here we have filed our affidavits, my lord. In fact, we'll file additional affidavit also.
Yes, my lords, we have received that.
Now, the only issue, my lord, though we have not raised in the pleading, but he is a civilian employee of BRO, my lord.
Border roads.
Border roads. And it appears, my lord, CAT is the alternative remedy for them, my lord.
But it is not.
At this stage.
But it is not, my lords. But may I just show that there are judgments of Guwahati High Court for the same relief, same exact thing, which has been referred, my lords.
Same petitioner.
Well, not for the same petitioner, but for within my department, again, my lords, promotion and challenging the APAR process, my lords. And I'll show it from Delhi High Court.
So that is one
Guwahati High Court
the
also.
second aspect, even the territorial jurisdiction of this honorable court, my lord.
Why?
He's only posted.
Case it disposed of.
My lord, they've challenged the so-cause notice, my lord. So the competence of the person issuing so-cause notice is on a different footing, my lord. And that's why.
What is the challenge here?
Here is challenge to the APAR.
But I'm posted in Shillong, my lord.
So posted, only posted at Shillong, my lord. The relevant period is 23-24 when he was not posted in Shillong also, my lord.
This APAR.
Yes, but my lords, I have received the order which I have challenged is what I have received when I was in Shillong.
24.
But I was in Project Sevak, my lords, in Dimapur. But my lords, the order which I have challenged has been passed when I was in Shillong and it has been served to me in Shillong. That's the order which I have challenged, my lords.
In my observation, that will not give you cause of territorial jurisdiction. So this is honorable court.
But this is I respectfully say, my lords, this is an last-ditch effort, my lords, to somehow stall the proceeding. Because anyways, my lords, may I just submit my arguments in that case, my lords? And my lords, I'll be very brief, my lords.
You have to meet those ground states also. Yes.
Yes, my lords, I'll do so.
Yes.
My lords, to start with, my lords, I'll request your lordships to have the writ petition, my lords, page number 298. Since this writ petition, my lords, categorically challenges the action of the respondents with respect to my 2 annual appraisals, my lords.
298.
Page number 298. It challenges 2 annual performance appraisals, my lords, one for the year 2022 to 23 and another one for 23 to 24, my lords. So therefore, my lords, I want to show and start with the my lords, policy with respect to this APAR which has to be adhered to by the respondents, my lords. But I'm reading from page 298 and I will trouble your lordships in reading 4 paragraphs.
Yes.
Para 1.2 onwards, my lords. It is in the interest, has your lordships got that? It is in the interest of every government servant that he should know how well or otherwise he is performing his job. Without this feedback information, it will be difficult for him to plan his career development in a systematic manner. In fact, he would be more interested in knowing his defects. His defects would affect his career advancements in the long run unless he comes to know of them in time and overcomes them by taking special efforts. The immediate superior officers of a government servant who is the reporting officer in the matter of writing his assessment report should be vitally concerned in writing the annual performance assessment report of every one of his subordinate in an objective and impartial manner. I'm emphasizing on this objective and impartial manner. As the superior officer functions through his subordinates, he also gets credit for the good work done by them. It would therefore be in the interest of the reporting officer himself to assess the performance of the subordinates objectively and thereby give them counseling and proper guidance for improvement of their performance. I will be showing that this has not been done in my case. Give them counseling and proper guidance for improvement of their performance.
Mandatory.
I'm sorry, Manoj?
It would therefore be in interest. See, only use be therefore in interest reporting officer himself assess the performance and thereby give him counseling.
Yes,
Manoj. Now, whether this is mandatory or
yes, but this is mandatory, Manoj, and I will also show from the judgments also. If there is any adverse report, if there is any any work which is not happening, because Manoj, the objective of this assessment, Manoj, I will also read from the other 2 paragraphs is that the employee should know very well, Manoj. The system of APAR on the performance of government servants is a means to an end and not an end in itself. The ultimate goal is to optimize the achievement of government policies and programs. This is possible only if the APAR lead to the optimization of the performance of the concerned government servants. That is why, my lords, the guidance is important. The main focus of the reporting officer should therefore be development rather than judgmental. That's the first thing, my lords. The APAR should be a true indicator of the achievement of the government servant. It should not be a mere tool to control and discipline him. But that is the second point I am emphasizing. Now, to answer your lordship's question, para 1.5. The system of APAR has 2 principal objectives, and the reporting officer should have a very clear perception of these objectives. The first and foremost is to improve the performance of the subordinate in his present job. That is why it's the guidance. The second objective is to assess the potentialities of the subordinate and prepare him through appropriate feedback and guidance for future possible opportunities in service. So, my lords, there are 4 things which come out of the policy. First is, my lords, this has to be done in an objective and impartial manner. 2, my lords, this has to be done so that he can get a guidance for his career advancement. Third, it is not a tool for punishment. Fourth, my lords, it should be done in a manner that the objectives, which is that the government's policies and the career advancement of the employee both can go hand in hand. These are, my lords, the four things which come out of the policy. Now, my lords, to start with, after, my lords, this policy, but may I straight away come to the APAR of 2022 and 23, which your lordships would find at page 55 of the writ petition.
So these are nature of guidelines only.
These are guidelines which has to be followed, my lords, by and large. And I would also show judgments, my lords. I will submit that to your lordship's consideration, my lords. Page 55, my lords. Has your lordship got that?
Yes.
My lords, the period is, my lords, 4th September 22 to 31st March 23. Has your lordships got that at the top, my lords? Now your lordships would come to page number 58.
1 second. Yes.
Has your lordship got that? Your lordship sees that this is part 3 authentication data. Second last column, my lords, would show guidance improvement communicated to the officer reported upon.
No.
Both the officers say no, my lords. Including, my lords, the reviewing officer. I'm only concerned with the remarks of reviewing officer. That is the remarks which I have challenged in this case, my lords. Your lordships would have Rajiv Chaudhary. He is a respondent in the present case. He says no. Now your lordships would turn to, my lords, for a minute, page number 61. Has your lordships got that? These are the remarks by my reporting officer, immediate superior to me. But your lordships would see that the pen picture by the initiating officer gives me 7. That falls within the category of very good, makes me eligible for promotion. Your lordships would see the pen picture. Shri Rakesh Chopra is a qualified officer and has worked as a staff officer to CE Project Sevak, which this is a very responsible post. The officer is aware of the rules and policy on the subject of roads and bridges. He is straightforward. But that's the pen picture given to me, and the marks given is 7. Your lordships would see below this, have you endorsed any adverse remarks? It says no, my lords. Verbal, written, both of them no. So there is no adverse remarks by my superior who is observing me work. Your lordships would now see page number 60.
Yes.
Point number 19. Page number 60, my lords. I'm sorry, I went back. Page number 60. Point number 19. Integrity.
Yes.
Out of 10, my lords, the reporting authority gives me 9. Has your lordships got that, my lords?
But reviewing authority says 5.
Reporting authority says 9. Reviewing authority says 5. Now, your lordships, I will come to this. My lords, I would want to show how the my lords, the vengeance and my lords, the harassment has taken place with Malafide, my lords. Your lordships may kindly have now page number 62. Has your lordships got that?
Yes.
Your lordship sees point number 31. Pen picture by reviewing officer. The marks given is 5.9. Just 1.1 below the marks which I required for promotion. But I would first read the pen picture and then come to something very glaring fact. The officer, despite his qualification, couldn't perform in any way in interest of organization. He couldn't function well in the team and his efforts got diverted against organizational goals. The non-submission of a power in time itself is testimony of such attitude. His loyalty to organization is shaky, and as he goes on to write at the bottom, and he is in the habit of criticizing his superior officers and disobeys their orders. He is an habitual offender. So, my lords, this is the pen picture which is given by the reviewing authority who is 4 levels above me. He is the DGBR, my lords, who did not have any chance to observe my work, did not interact with me during the whole period for which this annual appraisal is given. And, my lords, there is no specific instant to justify the remarks which is given against me. Habitual offender. Loyalty to the organization shaky. What are those instances on the basis of which you say that my loyalty to the organization is shaky? But I want to now come to your lordships, page number 59.
He's in the habit of criticizing superior officers, yes. Page
Well,
59.
no instance. he has to give instance, and I will come to the OMs, my lords, which say that whenever any adverse entry is given by any officer, they have to mention the specific instance so that the ratee officer can respond or he can, my lords, make a representation. My lords, may kindly come to page 59. But I showed 5.9. Your lordships remembers that, my lords. 5.9 marks. Your lordship sees page 59.
Yes.
Your lordship's middle row would show reviewing authority marks. Just besides the marks, my lords, 6, 6, 6, 6, 2.4, your lordships at the left within this would see certain, my lords, markings by pencil. Can your lordship see that, my lord? My lords, those will be visible in the below column, my lords. Para 70.17. But just below the marks, there are, my lords, marks in the pencil. My lords, I am referring to this one, my lords. These cuttings, my lords, written by pencil and then cut off.
So we can't discern it here.
What's
page 59?
What's page 59 and 60, my lords? What's the marks which have been given were first written in pencil.
We can't discern it here from your.
Muds, may I just pass on this, my lords?
No, how do you pass on the iPad?
Very well. Muds, the next page, your lordships, it is much more visible, my lords. Page number 60. Your lordship sees 18 Roman 5. 18 Roman 5. Ability to motivate and develop, my lords, subordinates. Your lordship sees 2 5s written there.
Yes, 0.5 and 5, yes. That yes.
Lords, this is something which might have not come in the printout, my lords, but this has been done in a manner. Now, my lords, may I just say what has been done? The final score was decided first, and then, my lords, the marks were decided how we have to reach that 5.9.
So after giving 5.9, now you have to distribute the marks accordingly.
Accordingly, so that 5.9 comes.
Okay.
Now, my lords, my next point is point 19, integrity. My lords, I am not referring to any rule now because, my lords, I want to first highlight what has been done and what are the extant policies and rules for this.
You are alleging manipulation.
I am alleging this is manipulation with a malified intent to stop my promotion in violation of the rules and policies, my lords. The last and the most important thing which I would now like to show, my lords, page number 61, page number 62. Your lordship sees at the bottom left sees date 26th September 2023.
Yeah.
This is by the reviewing officer. The rules provide that no remarks can be done after 31st August 2000 of any year. 31st August is the last date after which the officer forfeits his right. Lordships, I have now read the APAR. Now, Lordships,
we have to conclude. We will assemble again at 2.
Yes, my lords. I can start at 2 minutes. Whatever your.
After 2 years.
Yes, my lords. I'll start at 2 minutes.
All right, Dr. Mojika.
Because, my lord, to reply, I'll take one day, my lord. I'll reply tomorrow.
Tomorrow you can't reply tomorrow. Tomorrow school will be a bit busy. You can reply the after if you want.
Very well,
yes. You'll be here the after also?
Once I'll appear online, or if possible, I'll stay. That's the only thing I can do. But since I've come, if sir can do it today, that will be great.
Yes.
Very well, Mats.
Sorry for the delay.
No.
We are meeting us.
Please, my lords. Please. May I, my lords?
Yes.
To begin with, let me just answer the jurisdictional aspect, my lords, which has been raised by the respondents, my lords. The Honorable Supreme Court in 2017 itself has laid this issue to rest, my lords.
You've given a copy to
My lords, I have already discussed also with Sir, my lords. But I will just
discuss with him, meaning?
My lords, I just, my lords, informally, I was just sitting, my lords, and discussing. My lords, may kindly have, my lords, this judgment, page 9, para 18, my lords. But the background is in para 9, but I will not waste your lordship's time in reading that. Page 9, para 18, my lords. But this was a case wherein the issue to be decided was that since GREF officers, even though they are civilian, are constituted as a disciplined force and governed by Army Act, so whether their disputes will be referred to the AFT, Armed Forces Tribunal, CAT or High Court. So while after dealing with that issue, your lordships, in para 18, the Honorable Supreme Court says, on a plain reading of both the provisions, has your lordship's got that?
Yes.
It is noticeable that the language of the provisions is absolutely plain and the Act does not apply to any member of the armed forces, and therefore the High Court is justified in holding that CAT does not have jurisdiction to deal with the controversy. In this regard, reliance has been placed on the order passed on January 9, 1998 in the case of Vidyavati, as it appears to us that members of the GREF, which is the case herein, cannot move the CAT in view of the decision of this court in R. Viswan, and that impugned decision of the CAT cannot be sustained and therefore is set aside. Liberty is, however, granted to the respondent to move the High Court for appropriate relief if that respondent so desires. What's para 19 further? Be it noted that High Court has relied on the same. It has referred to the decision in L. Chandrakumar versus Union of India, but we are disposed to think that it is not necessary to be adverted to the same, as there cannot be no trace of doubt that the CAT has not been conferred jurisdiction to deal with the lesson question. So, with respect to court-martial matters, I will have to approach AFT. For any other service matter, I'll have to approach High Court. CAT does not have jurisdiction. Now, with respect to the issue of this court having territorial jurisdiction or not, since January 2025, I am posted in Shillong. The first impugned order, my lords, is dated May 2025, my lords. That is after I got posted here. And with respect to the APAR of 23-24, they have passed an order on 17th February 25. So both these APAR orders, my lords, are after I have been posted in Shillong. So, my lords, these were the two primary things your lordships asked me to deal with, and now I come to the merits of the case.
You on page 60?
Yes, my lords. And now, my lords, I will be, if your lordships want, I can just quickly do a recap of what I read. Very well, my lords. So, my lords, whatever I have read till now is with respect to what were the remarks. Yes. Now, your lordships, what I want to show is the representation which I sent to the department in this regard, which your lordships would find at page number 247. Against these remarks, I sent a representation, my lords. Annexure 8, page 247. Yes. This is representation dated, your lordships may kindly note, 9th November 2023. And lords, it is going to be very important in my case. What's my representation in brief, my lords, is, I'll read the first three lines. I seek your indulgence and kind consideration with respect to the unwarranted and uncalled for remarks against me in APAR 22-23 by the reviewing officer, which are made solely to punish me and spoil my career progression. But why I'm highlighting is because my case is of malafide as well as violation of the rules. The last line of this very paragraph is that there is no basis for leveling these allegations. I will also show the rules which say that when any adverse entry is made, any adverse remark is made, specific incident has to be mentioned, my lords, which is not there in the present case. But the next paragraph, it is also clear that the APAR exercise has been turned into a tool to punish me rather than as an aid for my development, which incidentally is the purpose behind APAR. I wish to draw your attention to the relevant fact, that is, I worked as a director works. Your lordships may kindly mark it. It is my request, my lords. I worked as a director works, Project Sevak Daily Order Part 1 and enclosed as Appendix D, which is a staff officer appointment to the Chief Engineer Project Sevak. The reporting authority for my case ought to have been the Chief Engineer Engineer Project Sevak. However, because of the officiating Chief Engineer holding the same rank and not completing the required 90 days under another Chief Engineer, the reviewing officer has now become the reporting authority and the accepting officer has become the reviewing authority in my case. Against the very basic necessity while carrying out the exercise of a power, the reviewing authority, who was the erstwhile DGBR and was 3 levels above me, did not provide any guidance for improvement as mentioned under part 3 of the APAR policy, thereby condemning me unheard against the principles of natural justice. It is pertinent to mention that the DGBR did not visit the AOR of the Project Sevak and I did not have the opportunity to meet DGBR during the reporting period, which would have enabled the DGBR to get well versed with my performance and conduct, in absence of which the adverse remarks against me have been made out of vengeance and only to cause irreparable harm to my career progression and promotion prospects. The DGBR was not familiar with the work I performed as Director Works, and also the DGBR knew me due to an ongoing court case I filed in the Delhi High Court to obtain a NOC from the department for my deputation, as well as a whistleblower complaint in which an order was also passed to stop all adverse actions against me till the adjudication of my whistleblower complaint. Thus, to teach me a lesson, the DGBR has chosen to spoil my APAR. Being heard and afforded an opportunity before making such unsubstantiated adverse remarks, particularly when the same are in complete disregard of the appraisal done by the reporting officer and have far-reaching implications on my career progression, including progression is my fair right under employee career progression. Words why I'm highlighting is I would show from the judgments that this is what the honorable courts in cases like mine have upheld. Unfortunately, the reviewing authority, that is the DGBR, has shown biasness due to the court case and not assist my performance as Director Works at Headquarter Project Sevak. Thus, I am making present representation against the assessment.
What happened to this representation?
This representation,
9th November 23.
9th November 23 gets decided in Mullards after 18 and a half months. 1.5 years, my lords, and your lordships would find that representation at your lordships page number 53.
The reply.
The impugned order.
Yes.
Page number 53, your lordships. And here, my lords, I'll be taking 5 minutes of your lordships to, my lords, just to substantiate how this is illegal.
22nd May, 9th 11 Lodge to dispose of this 11th May.
What's the first line? Whereas Shri Rakesh Chopra's Project Sevak has submitted a representation dated 9th November. So this is decided on 22nd May 25, 18 and a half months, my lords. May I, my lords, now go through what this order says. My lords, the first is the delay in deciding representation. Statutory time period for deciding this representation is 30 days. Your lordships, I will show that paragraph. Mandatory direction of 30 days. Decided in 18 and a half. My lords, may kindly have the time period which is in 4th line, 4th September 22 to 31st March 23. My lords, why I'm highlighting is because in this impugned order, incidents which have happened after 31st March have been taken into consideration for deciding my representation. My lords, every assessment has to be done on the basis of incidents of that period only. Your lordships may kindly have that para 2. And whereas Shri Rakesh Chopra submitted that RO has rated his BBM below benchmark grading, merits, that is good due to whistleblower complaint made by him coupled with the fact that he has filed a writ petition before the Honorable High Court of Delhi for seeking NOC for deputation. And whereas he further stated that the RO has not given any guidance for improvement, and whereas Shri Rakesh Chopra submitted that the grading provided by the RO is not commensurate with the pen picture. Merits, may kindly mark this line. Marks say something else. Marks are good. The pen picture is something else. And whereas in terms of the DOPT guidelines issued by OM number so-and-so 14th May 2009, comments of the initiating officer so-and-so regarding assessment under reference was obtained but not considered, my lords. And whereas the IO ADG Shri PKH Singh vide his letter dated 23rd January 24 mentioned that Shri Rakesh Chopra did not submit his aforementioned apart duly filled self-appraisal part in spite of several verbal and written instructions. Now I'll pause here for a minute. This is the case of the respondents against me. The case of respondents against me is that despite reminders, I never submitted my self-appraisal report, because of which the delay happened. There is a OM which says, and I will show that, my lords, the duty of filling the APAR is of the reporting officer and the reviewing officer. It is not of the rating officer. The rating officer has to submit it. But if he does not submit it, they will not wait for it. They will have to proceed. That is the first part of the OM. The second part of the OM is that if the reviewing officer and reporting officer do not complete that rating process within the timeline, their right will stand forfeited. The third part is if the reviewing authority and reporting authority do not complete that exercise within the time, they have to be issued the warning letter, not me. The respondents in the present case, they have turned this whole process into a victimization process against me, and they say that a warning letter has to be issued to me, my lords. But in this case, your lordships may kindly have the last line. And whereas comments of the RO, that is ex-DGBR, could not be obtained as he has been retired from government service on 30th September 23. Your lordships may kindly note the date. He made the remarks against me on 26th September 23, just 4 days before retirement, and 26 days after the deadline, my lords. My lords, next paragraph is again very important, my lords. And whereas the DGBR via their letter dated 6th June 24 have conveyed that the representation of Rakesh Chopra has been examined by taking into account the contention of representing officer, comments from IO, and feedback received from the environment. Rules do not permit any such feedback from the environment to be taken for deciding the representation. One,
you say that.
What I'll in sequence show all the rules, minutes. I just want to apprise.
How long will your sequence take?
I'm sorry, minutes.
How long to show the sequence it will take?
Muds, I'll finish it within 10-15 minutes, minutes. Okay. Muds, but I will try and minutes justify every point I am raising, minutes. This feedback cannot be taken. It has been submitted that the officer had failed to complete 3 time-bound departmental inquiries as IO since 2021. Your lordships is aware. May 2025, again, notes 1 year back, I had submitted the inquiry reports. Your lordships remember is from the last case. Notes 1 year later also they say I have not submitted. This is the ground of rejecting my representation, which is directly being monitored by CVC CVO. Moreover, the officer did not submit his APAR for the period from September 22 to March 23 with self-appraisal to reporting officer despite written and verbal instructions with repeated reminders. This reflects willful disobedience of instructions and attitude towards work. And whereas the DGBR wide letter dated 6 June 24 has not recommended for the upgradation of the grading, and whereas having considered the representation, whereas they reject my representation. The last thing I want to show your lordships is the authority which has passed. Deputy Secretary to the Government of India. But he's a level 12 employee. The reason I'm showing is he could have not passed this order. This order is without jurisdiction of the authority who has passed it. Now, my lords, I'll now straight away come to the regulations, my lords. Your lordships, I'll start by showing page number 302. Your lordships has Roman 4 at page 302.
Roman 3.
Roman 4 minutes. Page 302 of my writ petition. 302.
Yes, chapter 3.
Above chapter 3 minutes.
Right.
Above chapter 3.
More Roman 4.
The competent authority may consider the representation if necessary in consultation with the reporting and or reviewing officer. My lords, may kindly see. Only the reporting and the reviewing officer. And shall decide. Your lordships may kindly note this word. Shall decide the matter objectively based on the material placed before him within a period of 30 days from the date of receipt of the representation. But the respondents in their counter say this is only a directory observation. It is not mandatory in nature. The word used is shall. This is OM of 14th May 2009. Your lordships would see on this page itself, yes. 14th May 2009. As the next leg of argument, I would request your lordships to go to page 327.
Yes.
Annexure 20.
You same OM.
But this is different OM. Dealing with different aspects, I'll take your lordships through each OM. 16th February 2009, page 327, sir. Page 327, Annexure 20, sir. May I, my lords?
Yes.
Timely preparation and proper maintenance of ACRs. ACRs in BRO are called as APARs, my lords. As para 2, my lords, I'm reading. And my lords, I'll read the complete para 2. I kindly bear with me, my lords. As cases continue to occur where confirmation, regular promotion, appointment to sensitive posts, etc. could not be considered in time because of non-availability of ACRs for the relevant period, the matter of timely completion.
Yes.
The matter of timely completion of ACRs was further reviewed in this department, and it has been found necessary to prescribe a time limit after which the reporting and reviewing officer shall forfeit. Notice the word used is shall. His right to record the ACR. It has been decided that while the time limits prescribed in the aforesaid OM dated 23rd September 85 should be adhered to as far as possible, in case the ACR is not initiated by the reporting officer for any reason beyond 30th June of the year in which the financial year ended, he shall forfeit his right to enter any remarks in the ACR of the officer to be reported upon. So, my lords, reporting officer 30th June. Next is what I am concerned with. And he shall submit his ACRs held by him for reporting to the reviewing officer on the next working day. Madam, may kindly mark this line. Similarly, the reviewing officer shall also forfeit his right to enter any remarks in the ACR beyond 31st August of the year in which the financial year ended. But this is the first leg of this OM. But I am only citing 31st August is the deadline. The word used is shall forfeit because timely preparation has been the subject matter of this OM. But next line which I am reading is for my next APAR 23-24. The section entrusted with maintaining the ACRs shall, while forwarding the ACRs for self-appraisal with copy to the reporting reviewing officers, also annex the schedule of dates as enclosed with. It shall also bring to the notice of the secretary concerned in the cases of the ministry, department and the head of the organization in the case of attached and subordinate offices the names of those Group A and B reporting officers and Group A reviewing officers in the month of October after receiving the completed CRs who have failed to initiate. But may kindly mark this. Reporting and reviewing officers who have failed to initiate, review the ACRs even by 30th June or 31st August as the case may be. The secretary in the department, head of the organization in the case of the attached subordinate offices may direct to call for the explanation of the concerned officers for not having prepared the public duty of writing the ACRs within the due date and in the absence of proper justification, direct that a written warning for delay in completing the ACRs be placed in the ACR folder of the defaulting officer concerned. But the respondents have interpreted this OM in meaning that I as a ratee officer has defaulted because I have not submitted my self-appraisal.
Yes.
Merds may kindly have 3 lines of the next page in para 3.
Yes.
I'm reading from the third last line, para 3. In case both the reporting officer and reviewing officer had forfeited their rights to enter any marks, the CR format with the self-appraisal given by the officer to be reported upon will be placed in the ACR dossier. So, Mads, may I just explain this? I have to submit my self-appraisal within time. Thereafter, the reviewing officer will put the remarks within time. Thereafter, it will go to the reviewing officer within time. And that will be the final thing if I don't give any representation. Now, if I give self-appraisal, reviewing officer a reporting officer does it in time or it is not objected to. Thereafter, reviewing officer does not do it within time. The reporting officer's version becomes final. Yeah. If I do it within time and both of them don't do it within time, then my version, self-appraisal, becomes the final one.
That's your submission.
That is the OM says, notes. In case both the reporting officer, I'm sorry, Manoj.
Yes.
May I, Manoj?
Sorry. Yes.
May I, Manoj?
Will be placed in ACR dossier.
In case both the reporting officer and the reviewing officer had forfeited their rights to enter the marks, the CR format with the self-appraisal.
I mean, your submission that they both didn't do it within the time, and so.
No, Manoj. In the 22-23, I did not submit.
Yes.
They initiated on their own. Reporting officer has done it as per the process. That marks is already there, my lords, 7 marks. Reviewing officer, my lords, has done it beyond time and in an illegal manner. 23-24, I have submitted my self-appraisal within time, not considered by them. They have not initiated the process. No warning letter issued to the reporting officer and reviewing officer as to why you have not done it. And they have instead said that a warning letter should be issued to Rakesh Chopra, not to those officers, my lords. That is what I am challenging. Now, your lordships may kindly have page number 330, annexure 21. But I read that word feedback received from the environment. So with respect to that, I want to show. Page 330. OM dated 13th April 2010. Has your lordships got it?
Yeah.
But the subject is below benchmark gradings in ACRs prior to the reporting period 2008 and 9 and objective consideration of representation by the competent authority against remarks in the APAR or for the upgradation of the final grading, which is my case. Para 2. as per existing instructions, representations against the remarks or for upgradation of the final grading given in the APAR, previously known as ACR, should be examined by the competent authority in consultation, if necessary, with the reporting and reviewing officer. That is the only two officers they can consult, if any. While considering the representation, the competent authority decides the matter objectively in a quasi-judicial manner. So therefore, my lords, the principles of natural justice will come into play because it's a quasi-judicial function, on the basis of material placed before it. This would imply that the competent authority shall take into account the contentions of the officers who has represented against the particular remarks grading in the APAR, and the views of the reporting and reviewing officer if they are still in service on the points raised in the representation vis-a-vis the remarks gradings given by them in the APAR. So my representation could have been decided by the competent authority only on the basis of the remarks of the reporting officer and reviewing officer on my representation, not on the remarks in APAR. So after my representation is received, they will seek remarks from the reporting and reviewing officer, and only that can form the basis of deciding my representation, provided they are in service. In my case, the reviewing authority had already retired on 30th of September. So they have failed to do it in a quasi-judicial manner, and they have taken a third-party consideration of feedback from environment, which they don't tell what is that feedback. Lords, may kindly have now page number, my lords, 324. Lords, even though all my arguments, my lords, every point is important, but this is again the backbone of my argument. Your lordships would recollect from 9 to 5 in integrity. Reporting officer gave 9 and reviewing officer gave 5, my lords. Page number 324. Has your lordships got that?
Yes.
It is the OM dated 11th of February 2016. But before I read it, I just want to hand over one more DOPT OM, which is just issued in clarification of this. Sir. Your lordships has the 14th February 2025 letter, my lords. Adequate care to be exercised in filling up integrity column of APAR. The undersigned is directed to forward herewith following documents on the subject cited above, which are self-explanatory for information and necessary action. One is 3rd February, which is at the back portion, and 11th February, I'll read from the file. This may be brought to the notice of all concerned reporting and reviewing officers for information and compliance while recording, reviewing APARs of their reporting officers. May kindly have the next page, 3rd February. And I'm specifically reading para 2. I will disclose what is my argument. Integrity as a column could have only been filled up by the reporting officer. Reviewing officer cannot fill it because he does not have that direct overlooking on me. DOPT OMs dated 11th February 16, copy enclosed, is relevant in this context. Recording integrity as beyond doubt should be deliberate conscious decision by the reporting officer only. Your lordships may kindly mark that word. When he or she can personally vouch for the same based on close interaction with the reporting officer. In cases where this is not the position and yet integrity cannot in fairness be recorded as doubtful. That means they are in confusion. The option as listed under para 3 of the OM viz. Not watched the officer's work for sufficient time to form a definite judgment, but nothing adverse has been reported to me about the officers may be used. So the integrity column can only be filled by the reporting officer, and I know I'll further substantiate it. Your lordships may kindly have page 324 of the writ petition.
This is the OM 11th that is referring
11th February, and I am reading the relevant part at page 325.3. Page 325.3.
Further conveyed.
It is further conveyed that the remarks against the integrity column of APARs of the officer reported upon shall be made by the reporting officer in any one of the 3 options mentioned below. Lords, may I just pause here for a minute? Lords, may I just submit? I am addressing 3 things. 1, it could have not been done by the reviewing officer. 2, what is it that the integrity column has to be filled up with? That it has to be filled up only when they are clear about it. 3, if it is doubtful, what is the procedure? That is what I am going to read now. Reviewing officer puts doubtful. If it is doubtful, what is the procedure to be followed? A is beyond doubt. I'm sorry, yes. A is beyond doubt. If it is beyond doubt, you write it. Since the integrity of the officer is doubtful, a secret note is to be attached. It cannot be mentioned in the APAR itself. Then what is to be done? Not watch the officer work for sufficient time to form a definite judgment, but nothing adverse has been reported. But these are the only three processes which could be done while filling up the integrity column. Even if I have to argue against myself that yes, the reviewing officer can do it, even though the rules do not permit, still if he says doubtful, he cannot mention it. There has to be a secret note attached, and after the secret note is attached, there has to be an inquiry on it, so that arbitrariness and unfairness can be evaded in the process. But may I now come to page 339. This is part of the OM of 20th May 1972. 1972 OM, page 339, para 9.5, Roman 1. May I read notes?
Yeah.
Representations against adverse remarks should be examined by an authority superior to the reviewing officer. Superior to the reviewing officer, in consultation if necessary with the reporting and reviewing officers. This superior authority shall be regarded as the competent authority to deal with such representations. That's why I'm reading this line. Two things. This is one of my grievance because it is a violation of the rule. I specifically raised this point in my writ petition. Even in the counter affidavit and in the additional affidavit, the only response which comes from the respondents is that it has been decided by a superior authority, but they still do not name that authority in a writ jurisdiction, because they know that a level 12 officer has decided upon a representation which is against an order of a level 16 employee. DGBR is level 16, and it could have not been done by a under secretary. Now the last thing in this page.
That by an inferior officer.
I'm sorry, Manoj.
By an inferior officer.
Yes, Manoj.
Yes.
But it is like a district court deciding an appeal against a high court order, Manoj. That is what has virtually happened. Page 318, Manoj. Annexure 18. May I read, Manoj?
Yes.
This is OM of 23rd July 2009. Has your lordships got it?
Yes.
This is preparation and maintenance of APARs, a general OM, where in para Roman 2, in this page itself, it is said, a provision may be made in the APAR in the relevant section for remarks by the reviewing officer to indicate specifically the differences, if any, with the assessment made by the reporting officer and the reasons thereof. So if there is any difference, it has to be supported by a reason.
Yes.
Is your lordships with me, Manoj?
Yes, yes.
Manoj, in my respectful submission, when I was preparing this and I wanted to substantiate, I could have taken your lordships through each rule with that point, but I chose, Manoj, to read that document first so that your lordships is not troubled in coming back to the same document. But the points which I have established is that the decision of deciding my representation after 18.5 months beyond 30 days is illegal. But Mads, now the question would arise, why 18.5 months? The representation is of 9th of November. It is received by them on 13th of November. The comments are obtained on 23rd January of 2024. January 24, the comments are received. But why is it decided in April 2020, May 2025? But the answer is here. Your lordships may kindly have page number 257. Why after this much time, in spite of mandatory provision? Page 257. Has your lordships got it? But I was given the benefit of applying for deputation, para 14. In the light of the aforesaid, we dispose of the writ petition with all pending applications by directing the respondent number 3 and 4, which is the BRO, to consider granting age relaxation to the petitioner for applying for deputation till 31st December 24. Had my APAR been rectified as per the process, had everything fallen into the place, I would have become again eligible to apply for deputation. They only wanted to cross this timeline of 31st December 2024. That's the first thing. But why respondent number 6, I'm alleging malafide. The second reason is, my promotion became due in 2026. Specifically 18.5 months, again a 30 days is passed, so that by the time this representation is decided, my DPC is about to be held, and since my APAR is not as per the Lord's requirements, I can be denied my promotion. These are the two reasons, my lords, why it took 18.5 months. And why, my lords, such adverse remarks without any incident. My lords, I have been telling that yes, they have to mention incidents, but I'll substantiate that point. But just one more thing, ma'am. Just one more thing. Ma'am, thank you. So, Your Lordships, I'll first read the judgment of Tarsaim Singh, if Your Lordships has that. Has Your Lordships got the Tarsaim Singh judgment? Please, my lords.
Tarsaim Kumar.
I'm sorry, Tarsaim Kumar. Tarsaim Kumar versus Union of India. What's exactly case like mine, and I will only take Your Lordships to the relevant paragraphs. Your Lordships may kindly have para number 13 on page 5. Only the relevant paragraphs. I will only deal with the law, my lords, nothing else. Page 5, para 13. Has Your Lordships got it?
Yes.
Promotion is the only incentive in a service career. In the absence of any promotion to a higher rank, not only will the growth and development of the individual officer stop, but equally the department or the institution gets affected. Stagnation of an employee without there being any chance of promotion to further higher rank could well deter the employee from making any initiative to achieve higher targets, goals and objectives for the ultimate development and growth of the department and office which this office serves. But thereafter in para 14, they have extracted the APAR policy, and I want to, Your Lordships, draw Your Lordships' attention to point 4 within this para 14.
The reviewing officer.
If the reviewing officer is satisfied that the reporting officer has made the report without due care and attention, he or she shall record a remark to that effect in item 2 of para 4 or para 5, part 5 as the case may be. The government shall enter the remarks in the confidential roll. So only if he is not satisfied with the Lord's remarks. But thereafter, may I read point 10? Why I was saying feedback from the environment. Assessment should be confined to the appraisee's performance during the period of report only. Your Lordships would recollect reading that line that the IO reports have still not been submitted. And Lords would recollect June 24 they were already submitted. What's thereafter? Para 13. The secret note and the integrity. Within this page, Lords. The following procedure should be followed in filling up the column item relating to integrity. Has Your Lordships got that?
Yes.
If the officer's integrity is beyond doubt, it may be so stated. If there is any doubt or suspicion, the item should be left blank and action taken as under. A separate secret note should be recorded and followed up. A copy of the note should also be sent together with the confidential report to the next superior officer, who will ensure that the follow-up action is taken expeditiously. Where it is not possible either to certify integrity or to record the secret note, the reporting officer should state either he has not watched the officer, as the case may be. If, as a result of the follow-up action of the doubts or suspicions are cleared, the officer's integrity should be certified and an entry made accordingly in the confidential report. If the doubts or suspicions are confirmed, this fact should also be recorded and duly communicated to the officers reported upon concerned. If, as a result of the follow-up action, the doubts or suspicions are neither cleared nor confirmed, the officer's conduct should be watched for a further period and thereafter action may be taken as per BNC. What does this signify? This signifies that if any officer is of the view that my integrity is doubtful, the audi alteram partem principles of natural justice will come into play. A secret note will be attached. Thereafter, opportunity will be given to me. There will be an inquiry, and only based on that there will be a remark. In this case, the reviewing officer puts the remark without any inquiry. Spoils my APAR. Without mentioning any incident, why my integrity is doubtful. And I will show from point 6 in my work output, he gives me above good marks, very good marks. At one time he says my work output is very good, but integrity he says is doubtful. Your Lordships may kindly have page number 8, para number 15, my lords.
Of the judgment?
Of this judgment. I only highlight the law, my lords, nothing else. The observations of the court. But review DPC, I'll come into the why I am highlighting this is because in this case they have already done the DPC, the respondents on 10th December without informing the court, even in the additional affidavit. They have accepted it has happened, and they have also accepted a sealed cover procedure as adopted. So review DPC I'll be praying for, but coming back to the case. I am referring to Merds page 9, para 17. Merds, I will now be troubling your lordships in reading 2-3 paragraphs, but straight to the point. And Merds
Page 9 or page 8?
Page 9, para 17. These are exactly on the point, Merds.
Yes.
Before we examine the aforesaid DOPT guidelines and the instructions annexed with the appraisal report, let us recapitulate the brief controversy at hand. The case of the petitioner is for his promotion from the rank of commandant to senior commandant came up for his consideration before the DPC, which was held on so-and-so, and on both the occasions he was assessed as unfit. His juniors were promoted as against the vacancies of 10 to 11 and 12 to 13. As per the laid down guidelines, the 5 ACRs of the preceding years with the benchmark of a very good were to be taken into consideration by the DPC. Same is my case, very good. Only in the ACR of the year 8 to 9, the petitioner has been assessed as average, while in the other ACRs he has been assessed as very good. This average ACR of 8 to 9 is in fact the heart of controversy between the parties. The respondents have not disputed the fact that the said below benchmark grading in the year 8 to 9 was conveyed to the petitioner at a belated stage, that is after a delay of about 10 months. The petitioner has also made a representation dated, may kindly mark this, 2nd August 2010 to challenge his downgrading in the ACR for the year 2008 to 9. But his grievance is that his representation was decided on February 11. In my case, it is much more. In total disregard to the various guidelines issued by the DOPT time and again, and the same being conveyed by a non-speaking order without expressly dealing with the contentions raised by the petitioner in his representation. As per the petitioner, his representation should have been decided by an officer higher in rank to the accepting officer in terms of the DOPT guidelines, and therefore there is no valid decision accorded by the competent authority on the said representation of the petitioner. Para 19 minutes. The writing of confidential report, as we can find from the instructions attached with the APR, is serious business. Any casual or cavalier approach on the part of the designated officers can jeopardize the service career of the assessed officer. Promotion has been held to be an essential element of service, and it is expected of every management to provide realistic opportunities to every officer for boosting their morale and rewarding them promotionally for their hard work. The substantive growth in capacities to discharge work of greater responsibility has to be determined on the basis of past performance, which I'll come to later, my lords. Else there will be no motivation to do better or even to maintain standards. It leads to despondency and drudgery at work. The instructions as laid down in the APAR's criterion clearly spell out that the reporting officer and the reviewing officer should undertake the duty of filling up the APAR with clarity, high sense of responsibility and objectivity. It further states that the reporting officer should bear in mind that the objective of the assessment exercise is to develop an officer so that he or she can realize his or her true potential. It is not meant to be a battle, but a development process, a cumulative effort that ensures optimal outcomes. It further lays down that it should be the endeavor of each appraisal to present the truest picture of the appraisee apropos his or her performance, conduct, behavior and potential. In the teeth of these instructions and various guidelines laid down by the DOPT from time to time, it becomes abundantly clear that neither the reporting officer nor the reviewing officer, indeed not even the accepting officer, can adopt an erratic and a casual approach in evaluating the overall performance of an officer on the various parameters on which he is required to be assessed. The reviewing officer too cannot abdicate his responsibility by just putting a stamp of approval on the remarks given by the reporting officer. Simultaneously, he cannot regard his disagreement, may kindly mark this, with the report of the reporting officer without spelling out the reasons for his disagreement. The position of the accepting officer is no different. It has to be supported by reasons, my lords. Now, your lordships may kindly have page 11, second last paragraph. Above para 22. This is again taken from a Supreme Court judgment. We further hold that when the entry, that when the entry is communicated to him, the public servant should have a right to make a representation against the entry to the concerned authority, and the concerned authority must decide the representation in a fair manner and within a reasonable period. We also hold that the representation must be decided by an authority higher than the work who gave the entry. Otherwise, the likelihood is that the representation will be summarily rejected without adequate consideration, as it would be an appeal from Caesar to Caesar. All this would be conducive to fairness and transparency in public administration and would result in fairness to public servants. The state must be a model employer and must act fairly towards its employees. Only then would good governance be possible. But that is what has been laid down in Tarsem. I have now referred to one more judgment, Manudev Daya, which relies on Tarsem but goes a step further, my lords. Words Manudev Dhaya. I am reading, your lordships, from page number 5. What's page number 5, para and 30 and 31? I am not reading, but your lordships may kindly mark this. This is upholding Tarsem Kumar, my lords.
Okay.
Now, my lords, may kindly have page number 8, para number 41. The adverse remarks thus need to be appreciated in the light of the previous illustrious career and meritorious awards of the petitioner, which he had received from time to time, and also his outstanding gradings for the previous and the subsequent period, as has not been disputed by the respondents. Mods, I have a choice here now, mods, to read further or to show the previous record. Mods, I would request and trouble your lordships in just diverting for a minute from this judgment and coming to the writ petition for a minute. And I would read further, my lords. For a minute, my lords.
Yeah.
Words may kindly have the writ petition, my lords. Page 229. My lords is dealing with 22 and 23 and 23 and 24. So I want to show the back record.
The pen note.
Page 229.
Yeah.
This is by the initiating officer, the reporting officer.
Yeah.
Shri Rakesh Chopra is a soft-spoken officer who has performed his duties to Director Shillong and initially and his so-and-so. Subsequently, during the period of report, the officer was working in finalization of AWP and so-and-so. Merds, may kindly see the last line. Gracious. Merds has got that. Now, Merds, may kindly have the next page, 230. Reporting officer gives me 6.3. The reviewing officer increases it to 7.3. And Merds, may kindly have the pen picture. Shri Rakesh Chopra performed the duties of director so-and-so and for some duration director ESG as director so-and-so. He has been instrumental in preparing of so-and-so. He submitted all reports and returns in time to various headquarters. He also played vital role in approval of final bridge scheme and approval of changes. He maintained a professional attitude in resolving technically issues pragmatically. This is just 1 year before. Merds may now kindly have page number 219. This is 2020 minutes. Merds marks, your lordship sees 8.4. An experienced, professionally competent, dedicated as well as disciplined officer. The officer as so-and-so, I'll not read that. Last two lines. A well-behaved, well-matured and socially well-adjusted officer. This is 2020. Merds may kindly have page number 200 now. Has your lordship got that? Page 200. Reviewing officer. Shri Rakesh Chopra has worked well in a difficult area of deployment. The officer has always strived to live up to the expectations of the organization. But my loyalty to the organization is shaky as per an officer whose conduct I have shown. But I have always strived to live up to the expectations of the organization. Now your lordships may kindly have the most important one, my lords. Page 199. Has your lordships got that? Superintending Engineer Civil SE Rakesh Chopra is a sincere and hard-working officer who trained his task force well and exhibited meticulously following and expecting and execution of contractual and department works for the assigned AWP. He ensured that the set down targets are achieved with force, speed and quality, and funds are utilized judiciously. Notice this is his character. He was also instrumental in initiation, execution of so-and-so work on so-and-so road. He advised an efficiency, he achieved an efficiency of 103.66%, and undertook work on so-and-so road which is pending completion for the last 30 years. Last 30 years, an efficiency of 103. it only says that he's active socially and he's working well. That is what the
fine. So we just need a track record.
Very well.
So what do you want to show now?
Now, I want to show para number 42. Para number 42 of the judgment. But I wanted to show the past track record. Okay, since this judgment said past track record has to be kept in mind, my lords. I'm sorry, my lords, I troubled your lordships. Service of memos. Now, my lords, how will I draw parallel between this judgment I'm citing and my case? The reporting officer, Mr. Rajesh Tomar, was, while making the adverse remarks, gave no instances or no explanatory circumstances from which such inference has been drawn against him. The respondents, however, have relied upon 4 memos dated so-and-so that were found in the file of the petitioner to justify the adverse remarks. The Supreme Court in the case of State of UP versus Yamuna Shankar Mishra explained that at times the facts and circumstances may not be on record, but I'll give that liberty, but the conduct, reputation and character acquire public knowledge or notoriety and may be well within his knowledge, and the officer, before forming an adverse opinion, the reporting officer should share and confront the concerned officer with the said and then make it a part of the record. This gives an opportunity to the erring corrupt officer to correct the errors of the judgment, conduct, behavior, integrity or conduct or corrupt proclivity. If despite being given an opportunity, the officer fails to perform his duties or improve himself, the same may be recorded in the confidential report and can be supplied to the concerned officer so that he may have an opportunity to know the remarks made against him and also to give him an opportunity to make an appropriate representation to the higher authorities in case he feels aggrieved. Thus, what is significant is that if any unacceptable conduct or behavior which may not necessarily be documented is observed by the reporting officer, it should be communicated, an opportunity given to the appraisee officer to explain before it is made a part of the basis of adverse report.
Yes.
This is also in consonance with the principles of natural justice of being heard before being condemned. There is nothing on record to show that these 4 memos now relied upon by the respondents were ever served or brought to the knowledge of the petitioner, or any explanation was sought from him, or any warning was ever given or ever advised to improve his conduct during the aforesaid period of almost 5 months by the reporting officer. This supports the petitioner's claim that he has no knowledge of the memos till he received the copy of the PAR for the impugned period. Like, I don't know why they say my loyalty to the organization is shaky. Para 47 minutes. In the government, it is not the individual officers who bear testament to the affairs of the departments, but it is the record which speaks. Mr. Tomar may have been terminated and he may have been ceased to be a part of the respondents, but his official acts necessarily have to be supported by record. As observed in the case of Tarseem Kumar, writing of appraisal report is a serious business on which the career progression of a person depends. In Sukhdev versus Commissioner, the Supreme Court, while making a reference to Kashinath Kher, observed that it would be salutary for the controlling officer to give prior sufficient opportunity in writing by informing him of the deficiency noticed before writing adverse remarks against the SSC officer. In Abhijit Ghosh Dastidar, the Supreme Court observed that uncommunicated entry in ACR should not be taken into consideration while denying the promotion. The division bench in Commandant, this is exactly like my case, para 50 and 51, Commandant Ranjit Singh held that any adverse remark or any memorandum cannot be made a basis of writing in a PAR when it has neither been communicated nor any explanation is sought from the concerned officer. The record of the respondent speaks for itself that these memos prepared by Mr. Rajesh Tomar were never served or brought to the knowledge of the petitioner, giving him an opportunity to explain or improve his conduct. This corroborates the stand of the petitioner that the reporting officer was inimical towards him and had intentionally prepared those memos subsequently while writing the APAR after 7 months of submission of self-appraisal form by the petitioner, merely to support and justify the adverse remarks. The lackluster explanation that there are no record of service of memos leads to the inevitable conclusion that the record was clandestinely prepared by Mr. Tomar with an ill intent and element of bias on account of the complaint of corruption made by the petitioner against him. What's para 53? Next page, Malots. We find that these memos, para 53. We find that these memos could not have been considered while writing the PAR for the impugned period since they were never served upon the petitioner. Now, the conclusion, I want to see. Let's show, page number 12, para 65, last 3 lines. We are compelled to note.
Yes.
that the manner of issuing memos and their content clearly reflects that the reporting officer was purposely trying to find faults in the working of the petitioner. Moreover, when the petitioner was having a very good outstanding APAR for the previous and subsequent period, it leaves one perplexed as to what were the circumstances that led to a grading of 0 in the impugned APAR for 5 months. As already discussed above, the alleged instances neither reflected any dereliction of duty nor any insubordination towards the reporting officer, prompting to such downgrading of APAR. The extraneous circumstances like the complaint by the petitioner against Mr. Tomar, including a bias in recording of the impugned APAR, is self-evident. In the case of Sigdeo, the Supreme Court observed that while making remarks, the officer must eschew from making vague remarks as it can jeopardize the service of the subordinate officer. He must bestow careful attention to collect all correct and truthful information.
Okay, yes.
Much just one thing I want to highlight. I'll not read the complete part. Para 73, 74 and 75 at page 14.
Yes.
In Sanjay Doval, the division bench of this court observed that the petitioner was found to be having unblemished track record of over 22 years with an adverse entry being limited only to the impugned period of 8 months between 2011 April to December. The future promotion was withheld only on account of adverse remarks for the short period of DPC. The adverse remarks were found to be unjustified in the governed circumstances, and it was held that the adverse remarks were not justified and were expunged, and the review DPC was directed to be constituted. Para 75, just 2 paragraphs. We, in the given factual scenario, are compelled to observe that while the significance of APAR in the career progression can never be overemphasized, yet such whimsical conduct, and that too from those who are members of disciplined force, is difficult to comprehend. The members of the force face extreme challenging situations in the face of extreme adversity, and their survival is only in their camaraderie and being together. Such hierarchical personal animosity as evident from this intermediate APAR of 5 months is not only moral dampener but for a competent officer, but is detrimental to the entire force. Similar facts as in hand came up for consideration in Inspector G.D. Krishna Rajak, decided on 28 August, wherein the division bench of this court observed that since the competent authority has totally misapplied its mind, being the opinion that there was no useful purpose would be served to direct the competent authority to reconsider the ACR, it was therefore directed by the court that the review DPC be held to exclude the expunged APAR to consider the suitability of the petitioner for promotion within 4 months, and if the petitioner is found fit for promotion, he shall be promoted with all consequential benefits of seniority and pay fixation. I am not reading words. Page 78, if your lordships would see at the at its convenience. The factors
so
which
the
have
entire your case revolves around you discard whatever the reviewing officer said, and that's all what a reporting officer recorded. That should be taken into account. That's it.
That is the first thing, and Merz,
that is the first and last thing only.
Yes, and Merz, that is with respect to 22-23 APAR.
Yes.
For the 23 and 24 APAR,
no report certificate.
No Merz. Why? I will just conclude this in 1 minute.
Yes.
Your lordships may kindly have page 55 again.
So the 2 things only, to 22-23, it's a reporting officer, and for 2024 self-appraisal. That's it.
Why? Merz, I want to
You
show.
only said why. Now you only showed from the OM.
Yes, Merz.
Then why it should be accepted. So fine.
Yes.
So anything else over and above
Merz,
that?
just 1 minute argument. I have concluded for 22-23. What I want to demonstrate in the next 1 minute
For
by the clock is
23-24. Yes. Why it should be accepted?
Yes.
Appraisal, because
Yes.
it amounts to no report.
Yes.
On the part of the
Yes, my lords.
reporting review authority.
Yes, my lords. Merz, may kindly have page 58.
Yes.
Page 58 of the petition. Show me that 24th June submission. Page 58, your lordship.
Authorities you have?
I'm sorry, Merz?
What authorities you have on this self-appraisal?
Merz, self-appraisal, I've shown the rule.
Well, authorities.
But judgments on this, Merz, I'll submit with my written submission. But Merz, on this point, I don't need to, because I will show from the conduct of respondents itself that what I'm arguing is applicable. Page 58, your lordships has this.
Yeah.
Merz would see the last Roman, the 14th point.
Yes.
Indicate your agreement on not filled by the officer.
Yes.
So Merz, when I have not filled it, the reporting officer and the reviewing officer took it upon themselves and they filled it. No warning letter issued to me, not declared technically invalid, because the rule says if it is not filled, the reporting officer and reviewing officer have to do it. This process is adopted in 22-23. but not in 23-24. They follow the same rule in 1 year, but do not follow it in the second year. Your Lordships may kindly have.
Oh, because 2024 you didn't give civil appraisal.
But I gave it.
You give it.
I gave it, and they accept that I have given it. Your Lordships may kindly have.
Right. Sorry.
Page 66 and 67.
Right. No.
But page 67, they say APAR received from you wide above.
Yes.
And I have given it on 24th June. They admitted in the counter affidavit.
Right.
And Merds, what they say is page 66. Merds, just 10 seconds. They say para 6 at page 66. Headquarters Sevak to initiate no report certificate for the period from so and so with proper justification. Gap certificate for so and so. Competent authority has directed to seek explanation of the ratee officer for his non-submission of APAR within due date. In the absence of proper justification, warning letter be issued to the rating officer. Till date, no warning letter issued. Only documents are being created so that I can be shown to be an indisciplined officer in the back of such a record, my lords. And the warning letter has to be issued to the reporting officer and reviewing officer, not to me. But just one last submission.
Yes.
They keep on saying that despite several reminders, several representations, I did not submit my report. None of that has been produced on record. Because the rules say if the ratee officer does not submit, it is a public duty. It has to be initiated by the reporting and the reviewing officer. But I am not reading this judgment, but Guwahati High Court against the respondents itself, my lords, in one case, has taken cognizance of APAR itself. They have quashed that below benchmark grading, your lordships. I can show the relevant paras. I'll not read it, my lords. The para number 2, 3, 8 and 9 are important, my lords, in this. Guwahati High Court against BRO of a superintending engineer for his APAR, my lords, has quashed the impugned entries and my lords directed a review DPC to be held so that the promotion can be given. But now only the urgency. ACC approval is pending. DPC already done. In their counter affidavit at page 39, my lords, with respect to the quashed charge sheet, for the judgment of my lords, they say what they have done is correct.
Yes.
Page 39 of the counter affidavit. They justify their action against despite a judgment of this honorable court that the charge sheet was illegal. But I'm only requesting. I'm in the hands of my lords. The DPC has already been held. There has to be a direction for review DPC by expunging these adverse remarks. And 23-24 self-appraisal has to be done.
Yes, the day after tomorrow.
If it could be done today, I am here, I can be in a better position to assist my lords,
He's not ready today, so the day after tomorrow. Yes. So just for the hearing, day after tomorrow. Yeah. The point very short, only that is not really that long.
Oh,